All set, Dave? Great. Good morning, everyone. This is a convening of the Massachusetts Gaming Commission, and because we are holding this meeting virtually, I'm going to do a roll call of my fellow commissioners. Good morning, Commissioner O'Brien.
Good morning. I'm here.
Good morning, Commissioner Hill.
Good morning. I'm here.
Good morning, Commissioner Skinner.
Morning, I'm here.
And good morning, Commissioner Maynard.
Good morning, Madam Chair. I am here.
Excellent. Thank you so much. So today is December 6th, and it's public meeting number 406 of the Massachusetts Gaming Commission. Before I turn to our second item on the agenda and our general counsel, I would like to make a few introductory remarks. Today, as we begin our evaluation of these applications, we, as commissioners, are reminded of our principal responsibility to ensure the public confidence in the integrity of the gaming industry here in Massachusetts and the strict oversight of the gaming establishments and now sports wagering operators through rigorous regulation. We are reminded that the MGC's licensees will be held to the highest standards of compliance, including an obligation to maintain their integrity. As we have said in the past, the award of a gaming license in the Commonwealth is a peerless privilege, and our laws require gaming licensees to be held to those highest standards on a continuing basis. The MGC mission commits us to creating a fair, transparent, and participatory process that engenders the confidence of the public and participants. By law, that process is to maximize the benefit to the Commonwealth. But critically, it must minimize potential or realized negative or unintended consequences. I want to thank you, my fellow commissioners, for your commitment to that mission and for your thoughtfulness and diligence today and over the next several weeks as we evaluate these applications. I feel very fortunate to serve with each of you, particularly as we work tirelessly to implement this new law with the public's interest in the forefront. Our last several months and the months ahead have been demanding and will continue to be demanding on our MGC team, a team of excellence. We are very grateful for the contribution each of you make individually and as collaborating colleagues. We thank you for your dedication as public servants and commitment to the MGC mission. With that, let me give a brief overview of today's agenda. First, you will hear from our General Counsel, Todd Grossman, who will review the statutory and regulatory framework that will guide us as we evaluate the applications. Then, Plainville Gaming Redevelopment LLC, doing business as Plainridge Park Casino, will present its application for a Category 1 license using 205 CMR 218.06(3) as guidance. After that presentation, I'm imagining we're likely to take a short break, and then we will hear from GLI, the IEB, and RSM relative to the technology, suitability, and finance components of the application. That will lead us to a section-by-section analysis of the application, during which the applicant will answer your questions. Commissioners, staff members and our legal team, in addition to GLI, IEB, and RSM, will also be available to answer questions. To ensure that we have ample time to reflect, finalize any personal notes, memorializing our impressions, and follow up with an unanswered question, we will break shortly at the conclusion of each section. Then, after any further questions, for purposes of review of the Category 1 applications, I will seek from the group comments and a sense as to whether we have a consensus regarding the quality of the applicant's response to that section. Did the applicant not meet expectations relevant to the standard of review outlined by General Counsel Grossman? Did the applicant meet expectations? Or did the applicant exceed expectations? At any time during the public meeting, the commission may determine that an executive session is required for us to fully review and evaluate certain information in the application as we set forth in the agenda. Should we vote to go into executive session at this time, it is anticipated that the public session of this commission meeting will reconvene today at the conclusion of any such executive session. And after our review of the application, we will then consider whether we wish to proceed with our determination process fully or in part, or defer that decision entirely to another day. With that, commissioners, if you have any questions now, before we proceed with general counsel. All set for now? Okay, then we turn now to item 2 on the agenda. Good morning, General Counsel Gross.
Thank you, Madam Chair. Good morning, and good morning to all of you commissioners and to everyone who is joining us here at the meeting today. We're, of course, here so that the commission may evaluate the application received for a Category 1 sports wagering license from Plainville Gaming Redevelopment, LLC, which is the licensee that operates Plainridge Park Casino. Prior to commencing the review, it may be useful to set the stage by walking through the legal provisions and principles that will inform the commission's decision-making. So with that, I'll highlight a few provisions of the Massachusetts Sports Wagering Act, which of course has been enacted under Chapter 23N of the general laws. And then we'll go through a number of sections of the commission's recently adopted regulations. Of course, as always, questions and comments are invited along the way. So with that, allow me to begin with Chapter 23N. And I think the first place to look at is Section 6B1, which says, quote, that the commission shall issue a Category 1 license to any holder of a gaming license, as defined in Section 2 of Chapter 23K, that meets the requirements of this chapter, meaning Chapter 23N, and the rules and regulations of the commission, provided, however, that any holder of a Category 1 license shall not be issued a Category 2 license. What that means in the present matter here is that Plainville Gaming Redevelopment is a holder of a gaming license under Chapter 23K. Accordingly, if it otherwise meets the requirements of Chapter 23N and 205 CMR that I'll discuss momentarily, then it shall be issued a Category 1 sports wagering operator license. That said, the entity cannot also be issued a Category 2 sports wagering operator license, even though they would otherwise qualify for one. Only one license can be issued to this particular entity. Before we look at the commission's regulations that govern the licensing process for a Category 1 applicant, we should discuss what a Category 1 sports wagering operator license is. The term is defined in Chapter 23N, Section 3, to mean, quote, a license issued by the commission that permits the operation of sports wagering in person at a gaming establishment, as defined in Section 2 of Chapter 23K, and through not more than 2 individually branded mobile applications or other digital platforms approved by the commission, provided that the mobile applications or other digital platforms shall be qualified for and issued a Category 3 license, end quote. So if this applicant before us today were to be awarded a Category 1 license, it would be authorized to operate an in-person retail sports wagering operation at Plainridge Park Casino, and it would be authorized to operate 2 mobile operations. This Category 1 license is the tool that enables the licensee to operate through those 2 mobile platforms. But remember, of course, that the entities that will actually run those mobile or digital platforms first have to obtain a Category 3 license themselves. So now let's look at the commission's rules and regulations that have to be met by the applicant in order to be issued a license. And I think the best place to begin here is with 205 CMR 218, which, as you know, is the section that sets out the application requirements, standards, and procedures. The process itself has, of course, already begun. The administrative sufficiency review is performed upon the submission of the suitability portions of the application, And then the commission convened a public meeting yesterday in order to receive public feedback on the Category 1 applications. Momentarily, we'll walk through the factors and standards that the commission has set out for the award of the license. But prior to doing so, there are a few other provisions and principles that are important to keep in mind. The first is that the regulations provide that the commission shall analyze the factors and considerations set out in the regulations, but need not do so in any particular order or give any individual factor any particular weight, and in fact can assign a factor no weight at all if it's deemed appropriate in the circumstances. Next, you'll recall that the regulations provide that the commission may require or permit the applicant to provide additional information or documents as the commission deems appropriate in its review of the application. So if you're evaluating the information provided in an application relative to a particular factor, and you determine that further information is required, you may direct the applicant to provide it. Similarly, if during the course of the commission's evaluation, the applicant observes that there is additional information that was not provided that may be of use to the commission, it may request an opportunity to provide that information. Further, it's noteworthy that the present review is being conducted as part of a regular public meeting of the commission under the open meeting law and not in an adjudicatory proceeding. That means a number of things, including that all deliberations must take place in public, and that if necessary, the executive session provisions of Chapter 30A may be utilized, as the chair referenced in her opening remarks. As it pertains to this instant matter, Section 21A7 of Chapter 30A allows the commission to move into executive session to, quote, comply with or act under the authority of any general law. In the present situation, there is a general law that gives the commission authority to move into executive session. And specifically, that's Section 6I of Chapter 23N. And that says that applications for operator licenses shall be public records under Section 10 of Chapter 66. Provided, however, that trade secrets, competitively sensitive, or other proprietary information provided in the course of an application for an operator license under Chapter 23N, the disclosure of which would place the applicant at a competitive disadvantage, may be withheld from disclosure under the public records law. In sum, if there is any specific information that the commission would like to discuss, but that the applicant has identified as falling within the confines of that definition that I just read, and the commission agrees that it falls under that section, the commission may move into executive session to discuss that specific information. While the statutory provision of Chapter 23N relates to the public records law and not the open meeting law, to require that the subject information be discussed in public would nullify the whole purpose of that provision, which is designed to protect the information from public dissemination. Accordingly, application of the executive session provision I referenced is appropriate in this instance. And finally, before moving into the factors themselves that will guide the commission's decision-making, it's also important to recall that any finding the commission makes must be supported by substantial evidence. That term is defined as evidence as a reasonable mind might accept as adequate to support a conclusion. So, when making a determination as to whether there is support in the application to find that a specific factor has been satisfied or that it has not been satisfied, the commission will have to ensure that there is substantial evidence in the record to support the conclusion. There is one exception to this rule, however, and that is one area in which a heightened standard is applied, and that is in the review of the applicant's suitability. By the terms of Section 215 of the Commission's regulations, any durable or permanent, if you will, finding of suitability must be supported by clear and convincing evidence, not just substantial evidence. The substantial evidence standard is a slightly lower standard, and there is jurisprudence that tells us that clear and convincing proof exists when evidence induces in the mind of the fact finder, meaning the commission here, a reasonable belief that the facts asserted are highly probably true, that the probability that they are true or exist is substantially greater than the probability that they are false or do not exist. And for evidence to be clear and convincing, it must be sufficient to convey a high degree of probability that the proposition to be proved is true. And it must be strong and positive, full, clear, and decisive. So that's the definition of clear and convincing evidence versus substantial evidence. And of course, we can revisit these definitions and any of these other standards as we move through the process. So now, if I may, allow me to lay out the factors that are identified in section 218 of the regulation. As the chair mentioned, one way you may choose to move through the evaluation that will follow when we get to that part of the proceedings would be to take the application factor by factor and begin to draw conclusions as we move through it as to the quality of the information supporting each factor. You'll recall that the commission identified sub-factors under each of the factors in the regulations. Prior to beginning a discussion of any one particular factor, it may be helpful to pause to outline what each of these sub-factors are, though I will not do that right now. The factors are included in section 218.06, subsection 5 of the regulations. Each factor falls under the umbrella standard that the commission included in the regulations, which directs that in determining whether to award a sports wagering operator license, the commission will evaluate the application to determine, quote, whether a license award would benefit the Commonwealth, end quote. So that's the main standard that will have to be met in order to award a license. But in reaching that conclusion, that is whether a license award would benefit the Commonwealth, the commission provided that it will consider the following factors. And recall that the application itself was designed so as to elicit the information from the applicants in each of these categories. And here they are. Number one, that we'll look at the applicant's experience and expertise related to sports wagering. Number two, the commission will look at the economic impact and other benefits to the Commonwealth if the applicant is awarded a license. Number three, the commission looks at the applicant's proposed measures related to responsible gaming. Number four, the commission will look at the description of the applicant's willingness to foster racial, ethnic, and gender diversity, equity, and inclusion. Number five, the commission will look at the technology that the applicant intends to use in its operation. Number six, the commission will look at the suitability of the applicant and its qualifiers. And I'll come back to this one momentarily to add a little bit more texture to that. And number seven, the commission may look at any other appropriate factor that it deems appropriate within its discretion. So those are the factors that the regulation outlines that the commission should review in determining whether to award a license. And as I mentioned, I'd just like to circle back quickly to the suitability factor for a moment. You'll recall that the commission adopted section 215 of the regulations to govern suitability determinations in the context of sports wagering. And it included provisions allowing for a durable finding of suitability, namely the so-called final determination, if you will. Though it also included a provision related to a preliminary finding of suitability. In the matter before you here today, you may choose to award a durable finding of suitability if you conclude that the applicant and each of its qualifiers has already demonstrated their suitability by clear and convincing proof by means of the review that has been conducted under Chapter 23K, and that they've maintained such suitability on an ongoing basis up to the present time. In that event, no preliminary finding need be entered, and this applicant could move right into durable finding territory. In support of that principle, I direct your attention to section 6D of chapter 23N, which says that in investigating the suitability of an applicant, the commission may use information obtained from the applicant pursuant to chapter 23K Chapter 128A, Chapter 128C, or information from other jurisdictions where the applicant is authorized to conduct sports wagering. So those are all the factors that the commission must consider in order to make a licensing decision. As you work your way through the evaluation, though, it may become clear that a condition of licensure will be appropriate in a particular area. For example, you may find that the information relative to a particular factor is lacking. In that event, it does not mean that the applicant cannot be awarded a license. It simply means that that area may require to be supplemented with an appropriate condition. License conditions are described in Section 220 of the Commission's regulations. You'll recall that there are a number of automatic conditions, like the obligation to obtain an operations certificate prior to commencing operations, and that the operator comply with Chapter 23N and all of the Commission's regulations. But there's also a provision that allows the Commission to impose any other condition that it determines are appropriate to secure the objectives of Chapter 23N and 205 CMR. As a practical matter, I might suggest that the Commission begins discussing any additional conditions as part of the review of each individual factor. Then, once the Commission has made its way through all of the enumerated factors, but before any final decision is made as to whether to award the license, the Commission can shore up what those final conditions will be in the event the Commission is inclined to award the license. Once that's done, the Commission may decide whether it will award the Category 1 license, whether it will determine that the applicant is eligible to request a temporary license while the complete suitability assessment is performed, or whether the Commission will deny the license application for failure to meet the requirements of the regs or for violating Section 6E or Section 9 of Chapter 23N. At that juncture, a written decision will be prepared and issued commemorating the Commission's decision. And keep in mind that the award of the license does not mean that the licensee has the green light to commence operations. It simply means that the applicant, which will then become the licensee, would be eligible to work towards the award of an operations certificate, which is a prerequisite to conducting sports wagering operations. That process is described in Section 251 of the Commission's regulations and requires submission and approval of such things as their internal control plans, including their house rules, and compliance with any conditions that the Commission may impose as part of this licensing process. So that covers all of the points I thought would be helpful to touch upon as part of the overview guiding this process. I'd like to just stop there, if I might, and turn back to the chair and the Commission to see if there are any questions or any points that would be helpful to clarify.
Questions, commissioners? Commissioners, all set? General Counsel Grossman, can you just give me one clarifier? You mentioned after describing the difference between the preliminary and durable suitability decision-making, and you referenced I thought it was a Section 6 where there's a description. Could you just go through that briefly with me, please?
A description, I'm sorry, of the...
If you could just go over that point. I thought I lost you on after the durable versus durable versus preliminary suitability.
Sure.
I thought you then referenced the Section 6, but I may have misheard.
Section 6. I may have said that. Well, I'd be happy to just talk about
Yeah, that's great. So that would be helpful.
the suitability piece. So you remember that given the wide variety of applicants that the Commission anticipated it would receive, and the understandable time and attention that goes into reviewing the suitability of applicants, the Commission wanted to ensure that timely decisions could be made responsibly. So there were essentially two paths that were set out in the regulations as it applies to suitability findings relative to the award of sports wagering licenses. The first is what was referred to as a durable finding of suitability, and that is in section 215.01A of the Commission's regulations. In that situation, essentially covers an applicant that the Commission is comfortable while it's reviewing the sports wagering application has already met the clear and convincing standard and can be deemed suitable now, as opposed to further investigation and review being performed by the IEB and then coming back to you. I would submit that it's most appropriate on its face for application to the Category 1 applicants who hold gaming licenses under Chapter 23K, as they have already submitted themselves to a comprehensive background investigation and been deemed suitable under 205 CMR. And of course, the IEB has submitted reports to you detailing the supplemental review that it has performed. So you may find, based upon that evidence and the provisions of Chapter 23N, that the applicant before you today is suitable and there is clear and convincing evidence of its suitability, in which case you could award it a durable finding of suitability. And no temporary licensure would be awarded if you were to award them the license. They would just have the sports wagering license. By contrast, the Commission also set up a different path, and that was what we referred to as a preliminary finding of suitability. And you recall the idea there was that the Commission and the IEB would not necessarily have the time needed to conduct a thorough, comprehensive background check of each applicant and all of its qualifiers. So there were certain principles and provisions set out that under which the Commission could find that the applicant has preliminarily demonstrated its suitability, and so it could be awarded a temporary sports wagering license. But the understanding there is that in that event, the IEB would then continue a full investigation into that particular then licensee's background and investigation and come back to the Commission at a date in the future to provide all of its findings, at which point the Commission could decide whether the applicant and then licensee has met the clear and convincing standard. In that event, the applicant or licensee would have been operating, but operating under a temporary license instead of a, let's call it a permanent license. And so that was the distinction that is drawn in the regulations between the durable finding of suitability and the preliminary finding of suitability.
Thank you. It's really helpful. And of course, the section 6 that I was referencing, it's 23 and section 6. That's where that's from. So thank you so much. I think that was really a helpful reminder as we pursue today's discussion. Any other questions, commissioners? Okay. Then Councilor Grossman, if you're all set, I think we'll turn then to the next part of our agenda, which is the presentation of application for Category 1 sports wagering operator license to be submitted, that has been submitted by Plainville Gaming Redevelopment, LLC, doing business as we know it, Plainridge Park Casino. And I welcome today North Groundsell, the General Manager of PPC. Thank you. Good morning, North.
Good morning, Madam Chair. So if you give me just a minute, I will share my screen, and I've got a presentation that we will go through today. So we'll just bear with me.
North, before you get started, do you want to just reference who is also on your team available for questions? And then,
certainly.
and I should have offered that. My apologies. And then commissioners will decide, should we let the presentation flow and then ask our questions afterwards? Or General Manager Groundsell, do you prefer to be interrupted? It's up to you.
I'd prefer to get through all of it and then take questions, but we're happy to adjust to whatever the commission prefers.
Commissioners, are you all set with that plan? Okay, hearing no objection. Thank you.
Good morning, Madam Chair, and good morning, commissioners. So joining us today, and I'll reference them again at the end of this show here, are my boss, Aaron Chamberlain, our Senior Vice President of Regional Operations, as well as Chris Soriano, our Chief Compliance Officer. So Aaron and Chris are on the line. Also, as you know, Jay Snowden, our CEO, participated in the last few licensing hearings. He is in a board of directors meeting today that has been long scheduled, and he does send his regards. If there are any specific questions for him that we're not able to address, he is able to make himself available with notice up until 1 p.m. today. So with that, I will jump into our presentation. Our agenda today is pretty straightforward. I'll open with some introductory remarks about our presentation itself, and then we'll roll right into the highlights of our application, which covers our background and experience in sports wagering, the betting experience guests could expect, our plans for responsible gaming, our employment impacts, our continuing commitment to diversity, equity, and inclusion, and finally, a few words about our financial suitability. I'll wrap up with some closing remarks, and we will then be prepared to take your questions. So with that, a few items, just notes on our presentation itself. Our complete license application was submitted to the Commission on November 21st, 2022 via secure file transfer. This presentation is a supplement to rather than a replacement of our submitted application. The completed application represents our complete response to the license application, and any discrepancies between this document and our application are inadvertent. We redacted certain information from the application made available for public viewing, and those redactions were made based on our reliance upon an understanding of the Massachusetts public records laws, specifically the exemptions provided in Section C regarding unwarranted invasions of privacy, Section G regarding trade secrets, and Section N regarding records relating to security or safety of persons, buildings, or structures. We also redacted some information from the public form of our application due to federal securities laws covering release of certain information to investors. I will cover our safe harbor disclosure in the next slide. So based on the redaction, there may be some information in our complete application that we will not be able to discuss in a public setting. We will, of course, be responsive to questions regarding redacted portions in any executive session the Commission chooses to enter into. So with regards to the safe harbor disclosure, I'll read the first paragraph and let the second, much longer paragraph remain in there for the record. This presentation contains forward-looking statements within the meaning of the Private Securities Litigation Reform Act of 1995. These statements can be identified using forward-looking terminology such as expects, believes, estimates, projects, intends, plans, goal, seeks, may, will, should, or anticipates, or the negative or other variations of these similar words, or by discussions of future events, strategies, or risks and uncertainties. So with that, the first thing that we were asked to address in our license application was our background and experience as it relates to sports betting. And this slide shows that Plainridge Park exists within the broader ecosystem of Penn Entertainment. And that one is one that stretches across both the United States and Canada. We operate 43 properties in 20 different states, and we operate 25 retail sports books and online sports wagering in 15 different jurisdictions. As you look at the individual retail sports books, this slide is meant to establish our experience and expertise as a retail sports wagering operator. One of our very first retail operations launched at Hollywood Charlestown shortly after the PASPA repeal. Incidentally, I was a part of that launch as well as the launch at Ameristar and Blackhawk. So should PPC receive a license to conduct retail sports wagering, this would be my third launch of sports wagering. Additionally, our Vice President of Operations, Joe Wenzel, led the launch of sports wagering at his last property. So this would be his second launch. So we have experience and expertise at the local level, as well as experience across the company. Turning to some estimates regarding wagering volume. As of December 31st, 2021, Penn Entertainment had 24 retail sports betting locations across 10 states that produced $775 million in handle or wagers that generated $85 million of gross gaming revenue. This made us the second largest provider of retail sports wagering in the United States. And further estimates of our wagering volume, market share, and gross gaming revenue are provided within the unredacted version of our application. So each operator has a slightly different setup to the way that they operate their sports books, and I just wanted to lay out the entities that would be involved here at PPC. The first is PPC. You, of course, are very familiar with us. Should sports wagering be approved at PPC, we would contract with Penn Sports Interactive through an intercompany agreement. Penn Sports Interactive is a wholly owned subsidiary of Penn Interactive, and its ultimate parent company is Penn Entertainment. PSI would provide some key services, but PPC will be the one running the book. All the people working at the book would be a PPC team member, and all of those folks would be licensed by the commission. And I'm sorry, I was remiss in not noting that Jenny Brown, our Vice President of Marketing, this would be her second launch with regards to sports wagering as well. So then that leads us to the, I'm sorry, okay. So that leads us to our plans for the actual wagering space itself. Given the speed of execution needed to be opened by the end of January, PPC would launch its sports wagering operation in 2 phases. The first phase would be a temporary sports book near our Revolution Lounge. In this initial phase, we would have 5 teller windows and 18 kiosks. In one of our prior conversations, Commissioner O'Brien expressed some concerns about having kiosks in a racing area due to the presence of underage guests. We heard those concerns, and based on that feedback, we elected to locate all of our kiosks within existing gaming space. More detailed blueprints, including the surveillance plan for the area, are provided in the unredacted version of our application. Should sports wagering be approved at PPC, we would also begin working on a permanent sportsbook location. This would be a multi-million-dollar capital investment to transform the existing Flutie space into a Massachusetts-centric, fully integrated Barstool-branded sportsbook and restaurant. This is a format that we've seen work really well in other jurisdictions, and having the betting and food in close proximity has been well received by our guests in other jurisdictions. In this slide, you'll see to the left an overview of the entire space that shows the restaurant to the left of the entrance and the teller windows to the right. And the second picture gives you a little better view of the restaurant's look and feel. On this slide, there's a closer view of the betting counter. Should our license be approved, we would request that this area be designated as gaming space. As with our temporary location, this wagering area is beyond the security podiums, and entry would be for guests 21 years of age and older. As I mentioned in the prior slide, the sportsbook and full-service restaurant would be integrated with a bar and a dynamic audio-visual package. We couldn't be more excited about this project. We believe it would be a great opportunity for us to get this space back up and running, give our existing guests a new amenity, and give some new guests a reason to come visit us at Plainridge Park. Guests who are placing wagers at the property, at the retail sports book, those wagers would be fully integrated with My Choice, which is our award-winning loyalty program. When players place bets using their My Choice rewards card, they earn status, offers, and My Cash rewards, just as they do now when they enjoy other forms of gaming at Plainridge Park. On the employment side, our plans for employment include opportunities both within the sportsbook itself, as well as the space currently occupied by Fluties. On the sportsbook side, we would employ a sportsbook manager, supervisory staff, and tellers or ticket writers. And during busier times, the numbers shown here may not be enough, and we would add staff in proportion to the business volumes. On the sports bar, we would hire about 40 team members. The positions needed will include management opportunities in both the front of house and culinary areas, servers, hosts, bartenders, and other culinary positions. As we've previously reported, getting this outlet open would go a long way towards restoring the balance of female team members here at Plainridge Park. One of the questions people may have is, should sports betting be approved here? How would people make a bet? And with regards to how people would make wagers, we have two options and one neat tool to help them. Guests would be able to place their sports wagers either at an automated kiosk or at a teller or ticket window. They could also use our Bet Builder website to help save time. The Bet Builder is a website where guests can enter all of their bets. Once they're ready to place their bet, they scan the QR code that's generated at the bottom of the betting slip, and the betting slip would populate with any updates to pricing that may have occurred from the time they placed their wager or they selected that wager until the wager is placed. Now, wager pricing will be available via odds boards, odds sheets, the Bet Builder website, or at the teller windows. Additionally, team members would be prepared to answer any questions that guests may have regarding how to place a wager. Subject to all necessary regulatory approvals, and unless otherwise specified by the commission, the sportsbook at Plainridge Park would offer patrons the opportunity to wager on an estimated 5,000 or more wagering markets, where results can be determined on the field of play and can be provided by a box score or other statistical analysis. This incorporates over 1,000 domestic and international sports leagues across 45 different men's and women's sports, and includes exhibition, preseason, regular season, postseason, and all-star events for all approved sporting leagues. Professional sports league drafts of MLB, MLS, NBA, NHL, NFL, and WNBA. And of course, all of those betting catalogs are subject to commission approval, and we know that that is work that's ongoing. But that being said, in accordance with Chapter 23N, there are wagers that are specifically prohibited. In those instances, the sportsbook at Plainridge Park Casino would not offer wagering on high school and youth sports, injuries, penalties, and player discipline or replay reviews, proposition wagering on individual collegiate athletes, nor college sporting events involving a Massachusetts college, unless the institution is involved in a collegiate tournament involving 4 or more total teams. So turning now to responsible gaming, we note that PPC has a history of commitment to responsible gaming, and we've shown that commitment by our implementation and ongoing support of the MGC approved responsible gaming plan. We promptly report and notify the IEB of any potential breach of this plan, and we support our local GameSense advisors and their leadership through many channels, a few of which include our annual support of GameSense's Toys for Tots Gift Responsibly campaign, GameSense's Responsible Gaming Education Month, and Problem Gaming Awareness Month. Penn and Plainridge Park are also recognized for their responsible gaming efforts with awards such as the 2021 National Council of Problem Gaming National Corporate Newsletter Award and quarterly GameSense Excellence Awards to Plainridge Park team members. We would also continue that commitment with sports wagering. And so a few other comments with regards to responsible gaming. All of our work at Plainridge Park exists within Penn Entertainment's responsible gaming efforts. And at Penn, we have an exclude one, exclude all policy. And what this means is that anyone who is part of an exclusion program at any one of our properties is excluding from gaming at all of our properties, and we do not differentiate between the types of gaming. We have responsible gaming committees at both the corporate and property levels that meet regularly, and we train our employees when onboarding and also provide them with regular refresher training. We continually monitor research and industry updates with respect to responsible gaming, and we adjust our materials accordingly. We are regular participants in industry discussions and conferences on responsible gaming. And finally, we offer self-exclusion, financial restriction, and limit setting programs in both retail and online settings. We're also proud of our partnerships with the International Center for Responsible Gaming, the National Council on Problem Gaming, the Responsible Gaming Council, and the American Gaming Association. With regards to advertising as it applies to responsible gaming, what I'll say is, a continuing theme that we have here is what you've seen from Plainridge Park in the past with regards to our advertising and our responsible gaming efforts is largely what you will see as it relates to sports betting. So our advertising with regards to sports wagering will contain responsible gaming messaging, will reflect generally accepted contemporary standards of good taste, will strictly comply with all federal and state federal standards to make no false or misleading claims, will strictly comply with all restrictions placed on licensees in the Commonwealth through effective legislation or regulation, and we will comply with the American Gaming Association's Code of Conduct for Responsible Gaming. We specifically will not appeal to children or minors in our advertising, feature those who are or appear to be under the age of 21, will not claim or make claims or misrepresentations that gambling will guarantee social, financial, or personal success, will not be placed before an audience where most are ordinarily expected to be under the age of 21, will not imply or suggest any illegal activity, will not encourage people to play beyond their means, will not imply the certainty of a reward, will not exaggerate the chances of winning, and will not encourage irresponsible play. On the training and workforce development front, all newly hired team members complete a new hire orientation that covers the company's history, background, values, and guest service training. We also cover workplace policies such as respectful workplace, benefits, discipline, and paid time off. Additionally, new hires receive department-specific training. Sportsbook employees would receive additional training on money handling procedures, regulatory requirements, wagering types, wagering systems, and house rules. Plainridge Park offers internal training and development programs for our team members at all levels of the organization. We also offer tuition reimbursement to our existing team members. One of the flagship development programs that we launched in 2022 that you'll recall that we spoke about in our Q3 update is the Emerging Leaders Program. As you will recall, this program is primarily for hourly team members who are interested in pursuing management positions within the company. And we're proud to report that 5 of the 8 graduates from that program in our initial class were women. Finally, Plainridge Park Casino will continue to pursue the programs we discussed in our 2020 license renewal, including workforce development partnerships, building relationships with educational institutions, and participating in local job fairs outside of Plainridge Park. With regards to our workforce diversity, our application provides a listing of our employment numbers and diversity distribution as of the middle of November. The slide you see here is the data that we presented to you, to the Commission in our Q3 2022 update. As we stated previously, it is our belief that our percentage of female team members would improve with the opening of a sports bar. Although it's not reported in this slide, we're very proud to say that our diversity at the very highest levels of the property meets or exceeds the numbers listed here, with 20% of our VP and above group being diverse and 60% being female. Now, taking a look at our supplier diversity, each quarter, PPC comes before this commission to report our diverse supplier spend. This slide shows the figures from our most recently completed quarter. Diverse suppliers have been and will continue to be a part of our qualified spend here at PPC. In the most recent quarter, we met or exceeded all goals of diverse supplier spend. And now a few additional words about efforts that Penn makes and our ongoing commitment to diversity, equity, and inclusion. Penn is committed to building a diverse and inclusive workforce across our organization. Our executive leadership team and board of directors have over 100 plus years of experience in the gaming industry. Our board of directors is made up of professionals from many disciplines, including investment banking, asset management, tax accounting and consulting, advertising, gaming entertainment, and more. And their level of expertise is unparalleled. From a diversity standpoint, our board is 44% female and comprised of 3 military veterans and members who are white, Hispanic, Asian, African American, and LGBTQ+. Penn was included in the 2021 and 2022 Champions of Board Diversity by the Board of Executive Women and the 2021 Breakfast of Corporate Champions, which recognizes companies that lead the way for gender balance on their corporate boards. In 2021 and 2022, we were included in Forbes magazine's list of America's best employers for diversity. And we've received accolades from the All In Diversity Project and are certified as an age-friendly employer by the Age Friendly Institute. In 2021, we launched a $1 million diversity scholarship program for the children of team members that's goal is to who have a goal of pursuing secondary education. It was a resounding success in year one with 47 recipients, 58% of which are the first generation to attend college. We also created a $4 million plus STEM scholarship fund and internship program at historically Black colleges and universities in states in which we operate. The program now has 6 partner HBCU schools. In addition, we started a new pilot program to help mentor and develop hourly and early career team members who want to pursue leadership positions at the company, and that's the Emerging Leader program that we discussed earlier. Penn supports diversity investment and involvement in the sports wagering industry and has implemented policies to make diversity, equity, and inclusion a priority. Through corporate policies such as Penn's Supplier Diversity Initiative, procurement efforts are coordinated to achieve increased diversity spending and the development of new opportunities for diverse businesses. Penn's Supplier Diversity Initiative is a coordinated effort at the corporate level and across all of our destinations to develop strong partnerships with diversity suppliers. Putting diversity first, we more than doubled our diversity spend in our first year, partnering with businesses owned by minorities, women, disabled individuals, and veterans. Our 2021 diversity spend increased from $52 million in 2020 to $68 million in 2021, which is a 13% increase year over year. In addition, we're continuing to enhance our efforts through Penn's Small Business Incubator, a program that onboards minority businesses and assists them in growing from local to national suppliers within our company. Locally, Plainridge Park Casino maintains a diverse vendor base and actively supports its community, including ongoing financial assistance to the following organizations: the Boston Pearl Foundation, which is a 503c nonprofit organization. And the mission of that foundation is to advance and support education by providing underserved students with the financial assistance needed to attend college. Specifically, the focus of the foundation is to further the education of young Black women who enroll as freshmen in a 4-year college or university. Additionally, New Hope Organization, another 501c3 nonprofit organization, serves those affected by domestic and sexual violence. Their clients benefit from a full spectrum of programs they offer, allowing them to receive domestic and sexual violence services in one place. Their services include crisis intervention, violence prevention, life transition, and self-sufficiency opportunities, while promoting behavioral and systemic changes to reduce violence at the individual and community levels. We believe that diversity is a driving force that moves our company forward, and we're building a more inclusive company, giving our team members support they need in their work to help more people find their fun. Our most recently publicly disclosed EEO1 data reports that the company's workforce is 48% female and 46% of company-wide team members are of a diverse race or ethnicity. In 2022, Penn Entertainment launched a company-wide diversity training program. All team members were required to attend a series of courses covering diversity, equity, inclusion, belonging, allyship, and unconscious bias. We are currently in the process of delivering additional training to all leaders of people within Penn. And I will now say just a few words about our financial suitability. I know that there will be some more discussion about this to follow, but there are really 2 points that we wanted to draw out in support of our financial suitability. The first is one just around our stability as a company. As you look at our lease adjusted net debt leverage, we are at 4.3 times, which is well below industry standard, and our percent of fixed rate debt is at 85%. Our earliest loan maturity is currently in 2026, and we have a lot of liquidity available to us, $2.6 billion as of the most recently reported period. On the other thing that speaks well to our stability as a company is historically that regionally based companies, which Penn is an operator that exists within that space, performed far better than the Las Vegas Strip following the 2007 to 2008 downturn, and the current operating environment is much more favorable than that today. So in closing, we just wanted to say that, as we wrap up, we're really excited about this opportunity here at Plainridge Park. While this would be a new form of betting, look, we remain the same Plainridge Park that you've known for the past 7 years. We greatly appreciate the relationship that we've had with the Commission and with the Commonwealth and with our local and surrounding communities and partners over the last 7+ years. And now, as I said before, we're prepared to take questions. I think, Madam Chair, you might have said this may be a time that you were interested in taking a break. But again, wanted to say that my boss, Aaron Chamberlain, our Senior Vice President of Regional Operations, as well as Chris Soriano, our Chief Compliance Officer, are here and available as well.
Thank you, North. And Commissioners, if you'll allow me, I am thinking it makes sense for us to take a brief break, hold our questions, have the presentations that we're anticipating, and then make our way through the applications as I suggested, and revert back to General Manager Groundsell and his team for the questions that are pertinent to both today's presentation as well as the application. Does that make sense, or do you have particular questions that are particular to the presentation that are also relevant to our future discussions? Commissioners, does it make sense to hold, Commissioner O'Brien?
No, I think it does. I have, comments and questions, but I can put them on the end.
Okay, Commissioners, do you agree with Commissioner O'Brien and me that that might make most sense? Then we'll have our full, all the information in front of us to make our application review most meaningful and efficient. Okay, with that said, thank you, General Manager Groundsell, again for the excellent presentation, for your team being here. And it is 11 right now. Why don't we return at 11:15, Commissioners? Does that make sense? Or okay, thank you so much. Thank you, Dave. Commissioners, because we are reconvening this public meeting, number 406 of the Massachusetts Gaming Commission, I'll take a roll call, given that we're using a virtual format. Commissioner O'Brien,
Good morning. I am back.
thank you. Commissioner Hill,
Present.
thank you. Commissioner Skinner,
I am here.
thank you. And Commissioner Maynard.
I'm here.
Excellent, thank you. So we are now turning to item 4 on our agenda, and we will have 3 presentations and analyses. First, we will be hearing on the technical components of the application from Gaming Labs International. GLI was the first to write and set gaming technical standards, which are now considered to be the industry benchmark worldwide. GLI has continuously responded to the industry by innovating new standards and in testing, allowing regulators to feel confident that they are providing a safe, responsible method of revenue generation for their stakeholders and integrity preservation. We have before us today Kevin Mullally, who is Senior Vice President of Government Relations and General Counsel. He has 40 years of diversified leadership in law, regulatory policy, outcome measurement, economic analysis, and organizational administration. As GLI's primary liaison to elected and appointed officials, he regularly interacts with regulatory agencies, key organizations devoted to developing gaming policy, and senior level executives of gaming equipment manufacturing companies, casino operators, lotteries, iGaming operators, mutual wagering facilities, sports betting operators, and all related vendors. We also have Joe Funowith, Director of Client Solutions, over 16 years of experience Joe brings in the gaming industry with extensive experience in developing fantasy sports online game platforms. Joe also has over 16 years of product management and operations management experience. He's recognized for demonstrating a natural aptitude for overseeing all stages of the product development lifecycle. Good morning, Kevin and Joe, and thank you for your work that you've been doing with the Gaming Commission thus far, and thank you for today's presentation.
Good morning, Madam Chair and members of the Commission. It's a pleasure to be here today. We are enjoying our work with you. Whenever I hear that summary of my career, I feel really old, but happy to be here and give an overview of the regulatory framework that we promised you to ensure the integrity of the technology that would be used to protect the integrity that will implement sports wagering. I'm sorry. We assured you that the framework would be proven and consistent with other strictly regulated jurisdictions that had sports wagering that are similarly situated to Massachusetts. So GLI 33, as modified to align with the Massachusetts statute and the regulatory structure you have for the other forms of gaming you regulate, is the foundation of that regulatory framework. It is augmented by operational risk control requirements that include change control regulations and boundaries for and guidance with regard to internal control standards. As we've explained in the past, sports wagering is much more dynamic than the land-based gaming operations that you are more familiar with. And so the initial testing and certification, while essential, is only the beginning. It will require continuing efforts involving ourselves as your test lab and your staff, and cooperation with other regulators to manage these dynamic systems that are deployed globally but regulated locally. I would encourage you and your staff to continue your involvement in the regulators internet gaming network security task force that I think is essential to the efficient oversight of these systems in the long run. If we have a lot of very diverse requirements spread across a number of jurisdictions, it's actually going to be a net drag on risk control, and cooperation going forward will be essential. And so for the remainder of the presentation, I thought it best to turn it over to an engineer, not a lawyer. And so Joe Bunavith, a Boston native and our Director of Client Solutions, who has many years of experience developing these systems prior to coming to GLI, will discuss the certification, the process of certification, and the field inspections that will be precursor to the operational certificate that Mr. Grossman outlined in your process. Joe?
Yes, thanks for having me, Madam Chair and members of the commission. My name is Joseph Bonavith. I work directly with Kevin Morale. My title is Director of Client Solutions. If you pick up on a Massachusetts accent at some point during this presentation, I was born and raised in Millbury, Massachusetts, and attended UMass for engineering. So I'd like to give an overview on the submittal certification and verification process in regards to implementing retail, or referred to as like over-the-counter or like kiosks for sports wagering. But before we can take submittals at the independent test lab, the Mass Gaming Commission will have to approve 205 CMR 138, 238, 247, and 248, which are on the schedule for next week. After those approvals, the operators can prepare to submit their code bases for the entire sports wagering system they intend to deploy. That preparation includes an architecture review, which is a complete, comprehensive, and technically accurate description and explanation of the sports wagering system. Includes the description and layout of all hardware devices and virtual servers, all server and client software modules, including all the software versions, and the layout of all network communications between the various software and hardware modules. An explanation of all third-party integration and services is delivered at this time. Post the technical documentation review, the critical files regarding compliance will be identified and documented. We will run a supervised compilation of those source files, the signature of those files in the compilation steps, and the signatures of the compiled code. Once complete, the source code can be submitted for testing in a lockdown environment. The lab will verify the events, markets, point spreads, bet acceptance, results, corresponding timestamps, and all data logging for audits and reports. The verification and enforcement of betting limits will also be observed. All the edge cases and test requirements at that time around everything to do with those limits will be implemented. The verification of pre-event and live data feeds, bet settling, and corresponding logging and reporting will be noted, and we will review their change management process and procedures. Then at that point, post successful submittal and requirements for testing, we will move towards the certification process. The test lab will verify the changes made for the Massachusetts specific deployments. This will include source code differential and the change testing to the last reviewed version. We will evaluate the product to the Massachusetts specific requirements as which indeed have adopted GLI 33. And then we will transfer in all kiosk machine hardware, devices, and firmware. At that point, we will start issuing certificate for the versions that will end up in Massachusetts to take sports betting. Post the certification issuing, a field validation process will begin in conjunction or guidance from GLI and in conjunction with the MGC. They will verify all the machines on the floor match the certification report by model number, and they'll do the same for like all the bill validators, the printers, and all devices that are on the floor. We'll verify all the signatures of the installed firmware on the kiosk and the bill validator, and all the signatures for the production server and the critical file signatures as well. We'll run test data through a sampling of kiosks and retail point of sale. Likely a 2 to 3 day process will be in place to place wagers, let them result and settle overnight, reconcile those data and verify the reports and everything's recorded correctly. We'll then a review of the internal controls for procedures to operate the sportsbook, check technology for configurations such as proper setup for roles and user rights management, and potentially interview key personnel to ensure they know and follow all procedures from the operator's internal controls. And at that point, per blessing from the MGC, everything will be good to go to accept wagers in the state of Massachusetts.
Thank you, Joe. And Madam Chair, Commissioners, we're happy to answer any questions you might have.
Commissioners, questions for Kevin or Joe at this time? Commissioner Skinner.
Chair, are we holding questions? I just want to make sure I understand. I thought the request was to hold questions until the end of our presentation.
And I just wanted to check in. He asked if it makes sense, something specific that you would like to ask. I think it makes sense. I do want to point out that throughout the day, we also have Assistant Director Bruce Ban available from IAB on some of the technology related questions that Kevin and Joe have addressed. We will be going through the technology components of the application. Kevin, are you not available later in the day? That's the only one.
Yes, Joe will be available, but I have to leave at 1:30 p.m. your time. So
That's the only caveat, Commissioners. Something specific that Kevin raised that perhaps Joe might not be able to address.
In that case, no, I can hold my questions for
Hold our
Joe
questions.
until later.
Thank you much, Commissioner Skinner. And what we'll do too is if there is a question for you, Kevin, we'll make sure to be able to address it one way or another.
all right, thank you.
Okay. All right. Well, thank you very much. We'll hold our technology questions and then we will move on to suitability and our investigations and enforcement bureau's Chief Enforcement Counsel, Heather Hall. Good morning, Counselor.
Good morning, Chair and Commissioners. Thank you. Again, a tough act to follow. As you know, I always struggle with the tech, and I am glad I get to defer to people from GLI and Bruce's team on that piece. So with respect to my portion of the discussion here today, I will be brief. I know you all have a lot of matters to cover today. So as noted in the IEB's executive summary, and actually as General Counsel Grossman noted earlier this morning, in evaluating PPC suitability for the Category 1 sports wagering license under Chapter 23N, the Commission may leverage the information obtained in the suitability investigations performed pursuant to the casino gaming law under 23K. The criteria for suitability in the gaming law substantially align with the criteria for suitability in the sports wagering law. And as stated in the IEB's executive summary, with respect to PPC, in 2013, the Commission found PPC and each of its then individual and entity qualifiers suitable in connection with their initial application for a gaming license. And those suitability findings were issued after full investigations by the IEB. And then as new qualifiers joined the company, they were required to submit to the full background review process as well. The IEB conducted full background investigations as required by the statute and regulations with respect to those new qualifiers, and all of them are listed in the IEB's executive summary. The IEB submitted investigative reports to the Commission with respect to the recommendations on suitability, and the Commission issued positive determinations of suitability for each of those qualifiers referenced in the executive summary, again, both entity and individual, and also for those who joined the company subsequent to the issuance of the initial license. And as the IEB stated, PPC's license to operate a Category 2 gaming license under Chapter 23K remains active and in good standing. And, as we also noted, the applicants have a continuing duty to maintain suitability, as well as the continuing duty to update the commission in the event of various occurrences set out in the regulations and as required by the IEB. They also have a duty to inform the commission of any action that the licensee reasonably believes would amount to a violation of the gaming law. And I would just note, again, that PPC through Penn has continued to provide updates to the IEB, and the IEB remains in regular communication with PPC. And I think with respect to my prepared remarks, that's all I have at this point, but I'm happy to answer any questions that the commission might have.
Well, Councilor Hall, are you available for questions throughout the day?
Absolutely.
Commissioners, do you want to hold, or would you like to ask questions? Okay, then we'll continue with the presentation next from RSM US LLP is one of the leading providers, and I should say a big thank you, Councilor Hall. Thank you so much. RSM US LLP is one of the leading providers of audit, tax, and consulting services in the United States. RSM has been working with the Massachusetts Gaming Commission to provide insights and analyses to help the Commission in our evaluation of the applications. I'd like to introduce to some of the individuals who will be presenting during this meeting. Greg Naviloff leads New England Financial Investigation and Dispute Services Practice. Teresa Merlino leads the RSM's National Gaming and Hospitality Practice. Jeff Katz leads RSM's Strategic Finance Practice. Connor Laughlin is Director in RSM's Strategic Finance Practice. The RSM team has been asked to join the meeting and make a presentation related to certain aspects of the applications. Please note, RSM is not presenting on all aspects of the application. Specifically, RSM has been asked to provide insights based on their experience and research into the following sections of the application. That's with respect to section B2, subsection D, sports wagering experience, description of sports wagering operation. RSM has been asked to focus on applicants' estimated market share within each jurisdiction. We've also asked them to look at C2, projected revenue. RSM has been asked to provide insights into all aspects of the applicant's projected revenue. C3, subsections A through C, is on the construction, the gaming establishments. RSM has been asked to focus on the construction timeline and a reasonableness of the proposed gaming area. Section G3, the financial stability and integrity section, RSM has been asked to provide insights into all aspects of the applicant's financial stability and integrity. And then we invite RSM for their talking points at this time. Good morning.
Good morning. Thank you for the kind introduction. This is Greg Naviloff. I am a partner at RSM and joined by the other colleagues that you've introduced. Certainly wanted to thank the commission for inviting us to attend this meeting. We've got a lot of documents and a lot of information in a short period of time. We've done our best to get through all that information, a lot of back and forth discussions, making sure we had the right documents, but wanted to kick off this discussion and hand you over to the right subject matter experts. Teresa, who's on the line, will jump into and discuss briefly our approach, and then we'll get into some of the detailed discussion. And Teresa.
Good morning, Teresa. You just happen to be on mute.
Still on
Thank
mute.
you. I apologize for
There you
that. Yes. Thank you all. I appreciate this to be meeting with you here today. My name is Teresa Merlino. I'm a principal in our gaming and hospitality practice, and I've been involved with gaming since the late 1990s. and RSM has been involved with gaming for the last 50 years. So we're happy to support the Massachusetts Gaming Commission in this important exercise in providing sportsbook to the Commonwealth of Massachusetts. We understand the importance of the licensing process and the importance of these meetings. We've accumulated a diverse team of professionals to present on the topics as requested by the Commission. As of note, to specify and support what the chairwoman mentioned, we'll be focusing on B2D, sports wagering experience, C2, projected revenue, C3, A through C, construction of the gaming establishments, and G3, financial stability and integrity. I'd like to introduce Jeff, maybe Jeff and Connor, if you can briefly speak to your experience, and then I'll go over the introductions.
Sure. Thanks, Teresa. Hi, everyone. Jeff Katz here. I lead our strategic finance practice here at RSM, and I'm based in Boston. So spend the bulk of my career doing financial analysis and corporate finance and looking at entities and their overall financial capacity. Connor.
Hi. Good morning, everybody. This is I'm Connor Loughlin, a director with the strategic finance team. Prior to RSM and joining their strategic finance and FP&A team, I spent 12 years in BDO's BRS group, or Business Restructuring Services group.
So as we begin our presentations, please note this presentation is based upon documentation received as of December 2nd, 2022. The discussion prepared by RSM team is based upon our preliminary research to date and is subject to change if new information becomes available. Questions posed to our team may require further research. If we're unable to respond to a question before the end of this meeting, we will circulate a response to the Commission as soon as practical. I'll start with section B2, the market share for retail. The market share analysis is noted in B2D is closely linked to the C2 projected revenue analysis as requested by the Commission. Sportsbook revenue is the handle or the amount wagered multiplied by the hold percentage or win rate. The hold percentage can vary significantly from period to period based upon player wagering activity and particularly in unique markets. The betting mix, meaning the different types of games or methods to bet that the players may choose to wager on, and the results of those games played. For example, sometimes the underdog wins and they win big, and that may actually benefit the casinos or it may benefit the players. So the whole percentage is a difficult number to pin down typically, although we can certainly use referenceable information from other jurisdictions to understand what likely hold percentages will be over a period of time. The estimated market share is relevant to the revenue connections, and that's the first area that we'll be focusing on with B2D. As the market share influences the handle. Plainridge Park provided retail market share in other jurisdictions within their application, but did not explicitly include an estimated market share for Plainridge Park. As part of our analysis, we used external research to understand the likely Massachusetts sportsbook market size and used this external research to understand Plainridge Park's assumptions, which will be described here by Jeff today.
Perfect. Yeah, so in our review, Plainridge Park did not specifically provide with market share for the state of Massachusetts for retail sports betting. So what we prepared after looking at third-party market research, we prepared an analysis which extrapolated the low end and high end of estimated GGR. And so that's how we expressed market share, so gross gaming revenue, for both the retail and online sports betting markets. And based on that low end and high end, we then looked at the historical breakdown of between retail and online sports betting of states that have already legalized sports betting. And so we came up with a contribution related to the retail sports wagering for GGR, basically a range, a low and a high end of the range. And based on that, we were able to essentially calculate whether or not the forecast that was provided by Plainridge Park Casino was within the range that was implied by the third-party market research that we prepared. Then what we also did is we looked at the hold percentages over time for, that they had expressed in both their low, base, and high-end scenarios, which was the same across all three scenarios. And within that, we looked at data for all the states across the US that had legalized sports betting for both retail and online sports betting. And that was within the range as well. And it fell right around the middle over the past 18 months. Then from there, we again looked at their GGR in terms of the percentage growth annually to make sure that that made sense with the forecast provided by the third-party research that we analyzed. And again, they were within the range there. And that's how we came up with a total estimated GGR range that they fell within. And then in terms of revenue, what we did after that is we looked at the taxes, that the proposed taxes from the state, applied that to the GGR, the range that was provided by Plainridge Park Casino, and we came up with a taxable dollar amount that would go to the state overall. And based on those assumptions that were utilized, it seems to be within the range of reasonableness. And I'll pause there and see if there's any questions, or we can wait till the end.
I think that the commissioners are intending on holding questions as we go through the application. I think you're providing important context for us now, Jeff. So Does that make sense, commissioners? Are you in agreement? Okay, thank you. All right.
So I'll continue on then. I think just in general, what we found kind of as a summary is that the estimated projections as provided by Plainridge do appear to be in alignment and an agreement with the industry overall, and appear to be assumptions that are based on performance of other jurisdictions that Penn Nationals is competing in. Other areas that are included within the Section C2 include projections related to non-gaming sports wagering revenue and the methodology used to arrive at these projections. We observed that the non-gaming revenue projections were provided, but the underlying assumptions to come to those calculations did not appear to be explicit in the application. We did note that the location of the new sportsbook is going to be located in what is currently Flutie Sports Pub, and it may be of benefit for the commission to understand how the non-gaming revenue projections for the new venue compare to historical performance of Flutie Sports Pubs, given that it is in the same location. As it relates to the description of plans to compete with other jurisdictions, we did observe that there was discussion in the application related to marketing and advertising consistent with traditional and digital type advertising. They also referenced the My Choice player loyalty reward program as a component to help compete with other jurisdictions adjacent to the Massachusetts market. We have seen from an industry perspective, this would not be necessarily applicable to the applicant, but from an industry perspective, we have seen difficulties with other systems in other jurisdictions in the combination of a traditional loyalty program for like a slot and table game type program and a sportsbook offering. So the combining of those two databases and reward programs have been problematic in other jurisdictions. The commission may want to understand the approach and timing of linking the current My Choice loyalty program that's currently in place at Plainridge Park Casino with the planned sportsbook platform as noted in the application. So that concludes our overview of C2. So moving on to C3, which is the construction of the gaming establishments. RSM was specifically asked to focus on the construction and timeline and reasonableness of the proposed gaming areas. We observed the application, and as shared also in Plainridge Park's casino presentation, the retail sportsbook location will be a mixed-use space with a central location on the gaming floor and appears to be in a place which will have good foot traffic. The location would appear to promote high energy and entertaining experience, and the presentation as well as the application as provided by Plainridge Park does seem to be consistent with the industry. We compared the proposed square footage of Plainridge Park Casino's proposed new venue with other sportsbook markets, including the New Jersey, Pennsylvania, and Michigan sportsbook markets. While the square footage may differ between the properties, the proposed square footage by Plainridge Park Casino is generally consistent with the marketplace and appears to be in alignment with proposed revenue estimates. The applicant's proposed schedule is comparable to other remodels for the construction of similar size and duration. And this particular analysis was performed by our team that specializes in construction audits and does 100% construction analysis. The considerations for the construction timeline relate to supply chain impacts in particular. And as we considered their construction plans, we noted that specialty items with long lead times may impact the ultimate completion of the project. However, the remodel of this space does not appear to be a significant risk of supply chain issues, as the physical layout will not require specialized equipment as far as we could tell from the application. And there appear to be limited structural changes, both of which have extremely long lead times with the supply chain challenges. Other items, such as custom carpeting, custom furniture, or finishes may not be available within the time frame as provided by Plainridge Park Casino. However, the casino could very likely install temporary fixtures. For example, if the custom carpet that they'd like to install gets delayed, there still would be options to do some temporary carpeting, and as long as it meets safety standards, they could still open within the timeline. So with that kind of overall assessment, we found that the applicant's proposed schedule is comparable to other remodels and is in a position to be successful with the proposed timelines. And then now we have section G3, and Connor will speak briefly to this.
Thanks, Teresa. Yeah, it is part of RSM's engagement in assisting the MGC in its financial suitability review. We analyzed the current capital structure of Plainridge Park's parent company, Penn Entertainment. I know North Groundsel of PPC touched on this during his presentation, but I will go ahead just to affirm his comments for the commission. Since 2016, Penn has significantly grown its brick and mortar retail casino footprint. According to public filings during this time frame, Penn has increased its number of properties under management from 27 to 43, or approximately 60%. It is apparent Penn has incorporated these new properties into its growing portfolio without straining its available liquidity to support its ongoing operations. As of September 30th, 2022, Penn has a total debt balance of approximately $13 billion, an increase of approximately $3.4 billion since the fiscal year ended 2018. Despite Penn's growing total debt, it is apparent that the company has historically and currently maintains ample capital and liquidity to support its sportsbook operations at the PPC Casino, as well as its other ongoing operations. Penn has maintained an average total available liquidity position of approximately $2 billion for the period 2018 through September 2022. As of September 30th, 2022, Penn has approximately $2.7 billion in total available liquidity, comprised of $1.7 billion in cash on hand and $1 billion in availability under its current credit facility. And with that, I think this concludes our portion of the presentation, and perhaps I could pass it back to Teresa for any final remarks.
If there are certainly any questions at this time, although understanding that we will be available for the duration of the presentation to answer any follow-up questions.
Commissioners? Very, very helpful. All three presentations very helpful for really giving us a preliminary background context for our next exercise, which will be now to walk through the application. Commissioners, should we, would you like to take a 5-minute break or before we start that process, or are we ready to go? Commissioners? You know what, Commissioners, I'm going to take a 5-minute break. We'll be back at noon. Appreciate it. Thank you, Dave. Thank you, everyone. Again, this is a reconvening of Massachusetts Gaming Commission Public Meeting number 406. And because we're holding this meeting virtually, I will do a roll call. Commissioner O'Brien,
I am here.
Commissioner Hill,
Here.
Commissioner Skinner,
I'm here.
Commissioner Maynard.
I'm here, Madam Chair.
Thank you. Excellent. And again, thank you to all for the morning's presentations. And I believe I've asked, before we get started, I've asked Councilor Grossman, General Counsel Grossman, to just reflect and advise us on, as we navigate our review, the fact that there are redacted copies of the applications. And we, of course, have had the benefit of the unredacted applications. And that is what we have concentrated on in terms of our review. So, Councilor Grossman, please.
Thank you. So as the commission is aware, you do have redacted versions of, version of this particular application. And of course, it has also been posted on the commission's website. That was done in the name of transparency and what is sure to be a keen public interest in these proceedings. And the issue that we were addressing is the idea that under the public records law, that all documents are presumed to be public records unless the information or the document as a whole meets a particular exemption. And in the case of the applications we received, which number in the, I think, thousands of pages, it will be and would have been tremendously difficult to have been able to post those applications in a redacted fashion if we internally were to have gone through each and tried to apply the exemptions ourselves. And so what we asked for is that each of the applicants take a try at redacting their own application consistent with the law. And the law that specifically applies to this situation is, of course, the public records law, which contains a series of familiar exemptions, including the privacy interests that we're most familiar with, perhaps, but also a statutory exemption. And in the case of sports wagering applications, the statutory exemption was set out in Chapter 23N, Section 6I. And I read it earlier, but I'll just repeat it here to refresh everyone's recollection. And what it says is that trade secrets, competitively sensitive or other proprietary information provided in the course of an application for an operator license under Chapter 23N, the disclosure of which would place the applicant at a competitive disadvantage, may be withheld from disclosure under the public records law. And so each applicant went through and redacted their applications in accordance with that provision and any other provision of the public records law that they thought applied. It is important to point out that the commission and commission staff did not itself go through the applications and make those redactions. And so with that, those have been posted online and are available for public review today. So we do have a sense as to what the applicants think are the sensitive information or other documents that may be potentially exempt under the public records. And so with that, we will navigate this discussion accordingly.
I think your point that the commission and the commission staff not make those redactions is important. And I also must admit, I did not memorize them. And so I suspect I'm not alone. I see at least some heads nodding. So General Counsel Grossman and commissioners, please chime in. As we proceed, is there any guidance that you can give us as to if we start to navigate into something that is truly a permissible redaction or an area where we need to exercise caution under the law and perhaps move into an executive session if we find that that's fitting? How will you guide us?
Well, like you, I have also not memorized all of the exemptions, although I've certainly looked at them. The most efficient way of doing this would be to put the onus on the applicant to flag any areas of concern if the commission is about to veer into territory that may implicate these issues. And if they are to do so, we should consider pausing the proceedings to make a determination as to whether the information that is being elicited or to be discussed fits within the confines of an exemption. And if so, and that determination can be made in executive session if we need to know specifically what the theory is, depending upon the situation, then we can move into executive session as we noted on the agenda we might do, and then discuss just that limited piece of information or series of points in executive session, and then return to the public session to continue with the conversation. So that's, I think, the best way to go about this evaluation, if that makes sense.
Commissioners, any questions for General Counsel Grossman? Okay. All right. Then just a reminder, we are now moving to item number 5 on our agenda, where we will review and begin the evaluation of the application for Category 1 sports wagering operator license submitted by PPC. And our agenda notes the factors that General Counsel Grossman went through that our regulation establishes as criteria. At the end of the day, when we do ultimately end of the day, whether it's today or another day, we do engage in our determination process. Councilor Grossman and the legal team will guide us through whether or not we've met the burdens of evidentiary burdens, or not we, the applicant has met the evidentiary burdens. And that will be a process that we're familiar with in terms of our other work. Today, it's a little less familiar. If you will indulge me, I think General Counsel Grossman agreed it might be helpful for us, as I mentioned earlier, that at the conclusion of each section, and I will say, section A fully, section B fully, as we walk through those sections, ask questions, and if we need to go back in the section, it can be all very organic. At the end, I will seek, and we can ask questions of the applicant and any team members, as well as our RSM and GLI. But at the end, I'll seek a consensus generally as to the quality of the applications section. And we'll do, does it not meet expectations? Does it meet or does it exceed? So that's just a kind of a measure for us that legal will keep a record so that we know if there are deficiencies that we want to address ultimately, or of course, where there are, then we will applaud those places where we are particularly pleased. So with that, we will start with section A. Are there any questions or comments for the team or for the applicant on section A itself?
I can start, Madam Chair.
Okay, thank you. I'm just getting right into my notes. Sorry, excuse me. Yep, thank you.
So in terms of experience or expertise in regards to sports wagering for this applicant, I don't have any concerns at all with the application that was submitted or the presentation today. I have confidence in them in that regard.
Okay, and in terms of the actual section, Commissioner O'Brien, any particular concerns about what was submitted in terms of the actual? Anyone
Not in
else?
that section. No.
Thank you. Any other comments or questions around A, Commissioner Skinner?
A, no. B, no.
Okay, we'll move to B. If I just want to check in, are we all set with A? It meets our standard?
For consensus purposes, I agree with Commissioner O'Brien. The experience and expertise related to sports wagering in other jurisdictions, I think, has been fully vetted in the application as well as in the presentation today. So I'm okay moving forward to section B.
Excellent.
I will also join for the record and the consensus between my fellow commissioners.
So we have a full consensus on A, and thank you, commissioners, for elaborating. Excellent.
So my section A, Chair, is general information. The experience and expertise is B. So I do have questions and comments relative to section B.
I think that we're going through section B. Commissioner O'Brien, you wanted to maybe explain?
I just, point of clarification, I think the letter numbering on the app does not line up with the letter numbering on agenda. So I thought the chair was going letters on the agenda. That's why I said A. So just to clarify.
So actually, again, the factors that are in the agenda will be what we go through at the end of our position. Those are the factors for our guidance, and the legal team will be walking us through that when we make our determination. And that is our framework, and we will have a burden of substantial evidence generally, except with respect to suitability. But for right now, A is that just general application, and we will then move to section B. I wondered, Commissioner Skinner, I wondered if that's what was happening. So thank you for the follow-up question. Now we're moving to really the beginning of the substance of the application, and there are several subsections. B1 and B2 apply in this instance. B3 and B4 do not. Those are for category 3 applicants only. So walking through each subsection, and this is our first time doing this exercise, so we are allowed to navigate carefully. And while we're always nimble, it's okay if we move back and forth. We will get better as we go through this. But right now, BA is background in sports wagering. Everyone able to open that up? BA01. Any questions?
Madam Chair, I have a question that relates to, I think, section B overall. With respect to PPC's reliance on PSI, Penn Interactive, I assume is the same as Penn Sports Interactive. It's clear north in the application and in the presentation today that PPC is relying very heavily on the expertise of that entity. Could you just describe a little bit more the nature of the contractual relationship that PPC will hold with PSI?
Right. So Commissioner Skinner, that will end up being an intercompany agreement whereby PSI would provide certain services as a vendor to PPC. What I will say is that I look at this relationship a lot the way I look at when we buy, for example, a slot machine, right? We don't have specific expertise in building slot machines or developing the math models that are there. We rely on vendors to be able to provide us that technology. and to vet, to GLI, other vendors to look at what whether or not that equipment meets the criteria for the jurisdiction. Where we come into play is the operation, the efficient operation of that equipment. And so we look at this relationship very much in a similar way. We don't have the ability or the expertise to go out, for example, and to create our own slot hardware. That's just not something that we develop. So we use vendors to help support us in that situation. I will also say with regards to sports wagering that having another party who manages the markets or the risk of the large wagering pools is fairly common within the industry, and most folks use someone to help assist them in that process.
So is it accurate that PSI will be operating the retail sports book for PPC?
It is not accurate. They would be a vendor to Plainridge Park, where they would provide certain services, but all of the team members who are operating the book, the people who are booking the bets, the people who are, helping customers, all those types of things will be Plainridge Park casino team members who are licensed by the commission.
Okay, the services that PSI is providing to PPC, does that include marketing services?
It does not.
Advertising services? Okay.
It does not.
So it's specifically with respect to purchasing of equipment for sports wagering. The kiosk, for instance, the wager display boards.
So they provide that equipment, and then they also provide certain trading services. So trading services are eventually the folks who set the lines for us, who say, this is the wagers, this is the amount that this wager pays. That type of pricing information is set as a service by PSI. So think about it in terms of like the math model behind the game or the slot machine. Unfortunately, that's not a fixed thing the way it is with a slot machine. So there's somebody who manages that dynamically in the background.
And so PSI would be new to the Massachusetts market. And not only will they be collaborating with PPC on your retail sports book, but also I understand, although we haven't gotten there yet, on your mobile sports book. And so my question now then is for our IEB team. Heather, I think you're still on, is we have the suitability report, and I think I might be conflating suitability with the expertise and experience, but generally, what is the commission's obligation with respect to review of suitability of PSI as a potential qualifier for Penn Entertainment and or PPC? Because the current suitability report that we have before us does not mention PSI, nor does it mention this other entity that's reflected in the application, Penn Interactive Ventures. So I just need some help trying to understand the relationship there.
Commissioner, I'm prepared to answer that question if you're looking for an answer from IEB.
It's Councilor Hall, proceed. Thank you.
Thank you. So I appreciate the Commissioner Skinner's question. I think one way to help in terms of Commissioner Skinner's question and this overall question is to look at this in terms of the steps that we are taking and look at it as a step-by-step process. We have a executive summary before the commission today, and that executive summary has information in it that pertains to the suitability of PPC and its qualifiers. And that suitability was determined after full investigations by the IEB in the context of the gaming license under the 23K umbrella. So in terms of the step that we are at today, there is the application for the Category 1 sports wagering license from PPC. Now, there is also the question about PSI's application. That will come at a next step, which is PSI has applied for a Category 3 sports wagering mobile application license. And they are considered a tethered applicant to PPC, as well as one other applicant that will come before the commission. With respect to the analysis of PSI suitability, I would just kind of go back to what General Counsel Grossman was saying earlier. In that context, we will be providing a report that reflects simply a review for preliminary suitability. And that is based on, under the regulations that are promulgated by the Commonwealth, the submissions by the applicant and its qualifiers, and also an open source review of both the applicant, which is PSI, Penn Sports Interactive, and the individual qualifiers that are connected with that particular applicant. So that will be the category 3 step. Now, it's kind of an interesting dynamic in the sense that PSI is also a vendor. But that said, PSI is an applicant for a category 3 mobile application license. So I hope that kind of frames it in terms of going step by step, and happy to answer any further questions about this or anything in the suitability. I know there are matters for discussion, and I'm happy to be here with respect to any issues that the commissioners would like to discuss.
Madam Chair, I could probably chime in a little bit as to Commissioner Skinner's question. It sounds as if, Commissioner Skinner, you're also asking about sort of operational competence as opposed to integrity, honesty, and good character. Is that sort of your question?
Well, that, but more generally, what is the responsibility? What is the commission's responsibility with respect to PSI? Given that it is a vendor of PPC, will be procuring the sports wagering equipment on behalf of PPC. I understand that we're reviewing PPC's Category 1 application, but the way I read the application is that PSI is very heavily intertwined with PPC and its sports wagering endeavor. Again, we're talking about retail, but I also understand that PSI, they may have a greater role on the mobile operations side. So I'm just trying to understand how we undertake a review of PPC's application, given that we haven't really dove into PSI. And I understand the nature of a contractual relationship, but to me, because it's PSI that holds the contract with PPC's vendors, they're exercising control over the operation to some extent. So I'm just trying to understand how we process that.
Yeah, and you do have the option, as the chair mentioned earlier, about you don't have to vote today. You could make the decision to wait and get the information next week on the tethered operator and that evaluation and do it all together. So that certainly is probably a good option under these circumstances, because you're correct, there is sort of a connection there. So that may be helpful, but I'll defer to the chair and the other commissioners how they want to move forward.
Thank you, Executive Director Wells. So, Commissioner Skinner, you've raised an important question. I want to turn to the other commissioners for their questions with respect to Section B. But I do want to give General Manager Groundswell a chance to reply, to perhaps add any further clarity around PSI, which I think, it is a question that immediately jumps out at us, because it does, your initial section explains that it will be this contract that will be required to really operate its retail wagering operation.
Yeah, I think we can certainly get into the detail later on, and I'm not able to speak to the process the commission will follow to kind of make determinations on the vendor PSI or on their Category 3 application. But broadly speaking, I think the thing to bear in mind here is that PSI is a wholly owned subsidiary of Penn Entertainment, as is Penn Interactive. And so ultimately, a lot of the resources that we're relying upon ourselves to be able to deliver.
So perhaps commissioners, that might be a good segue for us to continue on section B and then perhaps put a pin in that issue and look more, perhaps think more deeply or take a deeper dive into suitability when we get to that section. Commissioner O'Brien, Commissioner Hill, Commissioner Maynard, Commissioner O'Brien.
Yeah, no, so there is an interplay here with the upcoming Cat 3s and this applicant. I was viewing PSI narrowly in this particular context in terms of the applicant being a PPC. But I see Commissioner Skinner's point, and I do think that some of the issues that I have and want to talk about circle back to the interplay of some of the marketing and some of the Cat 3s that we'll be dealing with next week. So.
Other comments?
I viewed it as the same way, Madam Chair, is that, if this were just in the Cat 1 space, we may actually not get as much information as we're going to get because it is in the Cat 3 space too. So I think we're going to get a lot of information about PSI and look forward to hearing it.
Thank you. So as we continue through subsections B1 and B2, are there particular questions that you want to raise in addition to Commissioner Skinner's?
Madam Chair, before we move on, if I may, I just want to join the consensus that I do have, that there's confidence in PPC's expertise and experience in operating the retail sports wagering.
Well, thank you. And again, I know that that's a factor, but today's exercise right now, this exercise is not to go through those precise factors. It's rather to look at the applicant's response and the quality of it to see if we, want to get more information from them. And please remember that is a possibility in all of the subsections under section B. If you want anything further, we can ask. If you want to applaud them for the quality of their answer, this is a good time to. And if you want to ask questions about the particular subsections, this is the right time. But we don't need to make our findings with respect to the factors laid out in subsection in item 5 on our agenda. That will be something, as again, our legal team will walk us through that very carefully because there's subsections to each of those factors in our regulation. So we want to be, as much as I appreciate everyone's consensus on that, and I think we have that, we will revisit that fully. Okay. So in terms of section B, I'll go ahead and then get the ball rolling. Thank you, Commissioner Skinner, for your first question. It was alluded to. This question was alluded to by RSM, and I may ask for Teresa to come back on it because in B2A, I believe, General Manager Groundsell, you do indicate that guests will be encouraged to sign up for the My Choice Players Card in order to earn benefits and offers with each wager placed. I have a 2-part or maybe a 3-part question, but I think, Teresa, you indicated that the use of the loyalty program has been problematic in other jurisdictions. Could you comment on that more generally? And then North, I will be asking you to let us know really what is happening right now with the player card information and whether or not it's being transferred to potential online sports wagering partners. So that's really what I'm wondering, what the status of that information is, and then I'll have a 3rd-part question. So Teresa, thank you again for earlier your presentation and for your ongoing advice.
I'll just revisit briefly the challenges, the operational challenges that are occurring in other jurisdictions. So you have the Usually it's the operator, the brick and mortar operator that's offering the retail sports book, similar to how PPC has proposed their operation. The brick and mortar operator will provide staffing, they do cashiering activities, they monitor, patron activity in the retail space, and support marketing efforts. So what we saw proposed is very consistent with the rest of the industry. But there's typically a third-party platform provider. So that's the actual wagering platform that is managing the lines and managing, kind of the payout ratios and providing the technology that enables the retail sports book to offer the game. So those third-party platforms, because of the explosive nature of the industry, have often been built outside of, I would say, the traditional gaming IT framework. So what that means is that you have more, I would say, more heavily software-driven companies versus traditional slot machines or table game type systems that have always understood the importance of having an integrated kind of, or not always, but have evolved to understand the importance of an integrated Players Club loyalty program, right? So if you have a card at the table games and you earn points there, you can also earn points at the slot machine. And that's all under the umbrella of the traditional brick and mortar environment. So that's that player loyalty program. What we've seen in other jurisdictions is because you're bringing in a third-party platform, there's been a disconnect between the loyalty program at the sportsbook level and the loyalty program with the brick and mortar, meaning that players may have two separate accounts, they can't merge their accounts, they can't combine points. And while that just may be the operational reality that the Commonwealth may need to deal with, I think it would be helpful for the Commission to understand the applicant's approach to having, integrating, either planning to integrate those loyalty programs, or perhaps they already have an opportunity, they've already integrated those and they don't anticipate any issues, or they may have a 6, 9, 12-month plan to work towards some sort of integration system. And so that's just the industry overall, and that doesn't have any, the application was neutral to any plans that PPC may have, and whether these issues may or may not relate.
Thank you.
On that,
Yes, if you'd like to.
I'm sorry. On that issue, Madam Chair, we are already fully integrated. So they're not two accounts for players. All of their tier credits and all those types of things go to a single account.
So that's really helpful to know that it really was more of an integration issue than something further. One question I'm struggling with, and it might be something for you, Joe, or Teresa, as well as the applicant. Is it safe for me to assume that in the sports wagering landscape across the country, as operators come online, like just the position that we are in Massachusetts, that they might be already cultivating their customer database so that when Massachusetts sports betting is actually legal, our framework is in place, those accounts are set up? Or am I assuming that they will pause and wait for that? In other words, across the country, or could they be using their, cultivating that database now to get Massachusetts folks on board? Is that a landscape you're familiar with, Joe, generally?
In general, that answer is yes, and that's pretty typical throughout the entire gaming industry, whether it's brick and mortar, digital, sports betting, online, anywhere. The big corporations that dominate the landscape have larger databases, and when they move into new markets, they're able to onboard customers quickly. It's pretty kind of standard stuff, so to speak. Yep.
So that's right. So what about if they're setting up? Can they also set up their sports wagering accounts that customers could they do that in advance of our?
Technically, there's nothing there to stop them, depending how the operator has it set up. Yes.
And
So
could
the
they
answer
make,
is
could they make deposits too as well?
as well. Technically, there's nothing there to stop that as well. Yep.
In your experience, do regulators include regulations that would preclude deposits until?
I would have to specifically look up that. Off the top of my head, I can't answer with confidence, but I want to say not usually, but I will follow up with something specific there.
So, North, now I'll just ask if that's something that, you know, whether it's happening with respect to PPC and its anticipated tethered partners.
So at this point, we didn't believe that the commission had made a determination yet on pre-registration. It is something that some other jurisdictions have allowed. But at this point, we thought that was an open issue.
Thank you. And in fact, I think it may be, commissioners, an open issue for us to consider the risks attached to that. So I see both Joe and Kevin, if you're chiming in.
Yeah, so I got your answer back already.
Okay.
And the answer is no, there's no other jurisdiction that actually disallows that money to be deposited in what they call a single user type account. And quite often operators will also use a pre-registration process where the market is not technically open for taking bets yet, but they do allow onboarding, knowing that it's coming, where they'll use promotion, or the marketing team will use promotions, sign up now, capture their username or first, last, and email, and then post the launch of the actual sports betting or application. Now, this is mostly going to deal with mobile and Cat 3. When it comes to retail, it's going to be more anonymous betting over the counter. So specifically with the mobile operations that deal with like a single sign-on concept, you have one username, one email, one account. And when you enter that specific jurisdiction, and launch to bet within that you're geolocated, your KYC, know your customer, verified within that jurisdiction, and that will all happen before you can actually place a wager.
Yeah, and Madam Chair, if I could take a moment to address the larger issue of these closely monitored network of third-party service providers. Not only is it the norm, it's a good thing. And it is not unusual, not only in the gaming industry, but in other areas of highly regulated KYC, like financial services. We're highly dependent on those third-party experts, just like you are with, as an example, you have an expert niche industry in geolocation. You have a expert niche industry in payment providers. And so the fact that the operators are using this portfolio of service providers is good. And one of the frustrations from a regulatory perspective with traditional land-based casino is largely the ability to generally gamble anonymously with cash. That is what is so good about the online delivery channel, is that unlike when you walk into a casino, I don't know who you are, I don't know how old you are, I don't know where you're from, I don't know where your money came from, I don't know anything about your player history. You're largely able to kind of go there in a ghost-like fashion. That's impossible in an online environment where I know exactly who you are, I know where you are, I know how old you are, I know where your money came from, I know your entire player history, and now I can provide you with a lot more tools to be able to manage your behavior. You can set limits for how much time you spend gambling. You can set daily and weekly or monthly limits for how much you spend. But that's all dependent on these expert service providers. So just want to emphasize that it's the norm, and I think there are tremendous regulatory benefits to it. The new regulatory skills that are needed is the ongoing operational risk control of that whole more dynamic process. And that's what I think we've emphasized in the GLI University training, and that your staff and the commission, I think, is embracing.
So that's very helpful, and I think I want to just Ben, General Manager Carousel North, you have said that you were waiting to see if there was a determination from the Gaming Commission of this issue, and so we want to be able to provide that guidance, whether it's through an internal control, a reg, whatever is appropriate, I think. Commissioners, I'm hearing it's the landscape. I'm not surprised by that. I have to say I had some equity issues in mind as the retail entities are standing up. They have direct access to new customers, but as I understand it, probably any potential sports operator in Massachusetts could be, in fact, cultivating their customer database as well as loading the customer's potential wallet, virtual or like electronic wallet. So I think that was a little bit of a policy issue in my mind, Kevin, whether there's any equity issues here, but it sounds as though this is the general landscape. And I guess what I'm hearing is that from because of the third-party experts that are giving the guidance to the operators, the risks are low to the consumer.
I think allowing sign up for all the operators at this point is a pretty low risk because they're not able to go live. It avoids some bottlenecks and some rush that they're certainly capable of handling it, but it's always better to do this over time. And the risk of doing something inappropriate or wrong is so grave that I think the operators would be very conservative in how they implemented those pre-signups. But it's certainly a policy decision for the commission. There's no technical reason to say yes and no technical reason to say no. It's just your preference.
Okay. North, did you want to comment?
No, the only thing I would say, at this point is obviously it's an ongoing issue. We'll continue to watch it and look for the commission's direction.
Okay. Commissioners, I don't know if you have any comments on that, but I'm of course looking at General Counsel Grossman, how we would proceed here if we need to give a little bit more guidance to our applicant here.
Well, I made a note that this would be a good subject to discuss as part of any license condition, perhaps. That's one way to address it. And then, of course, generally, we can adopt a regulation that encapsulates whatever policy position the commission would like to take, as Kevin just laid out. Of course, there should be uniformity across the landscape with whatever the decision is. But I think it can be handled in either or both of those ways.
And I would also add on, Councilor Grossman, that I understand that it's difficult because Penn is involved in the name of like all the entities that are involved in this, but we do not offer account-based wagering at the retail level. So people can certainly sign up for a My Choice card today at our property in order to establish an account, but they're not able to load any dollars onto that account at the retail level as it exists currently.
Thank you.
Yeah.
Okay, commissioners, do you have other questions on on section B of the application.
Madam Chair, just relative to the landscape, can I ask Joe to repeat his opening line in his answer to your question? I only got there's no other jurisdiction that disallows, and then I didn't hear the rest of what you said there.
Depositing.
Okay, thank you.
Commissioner Maynard.
I just want to follow up on that point that you brought up, and it's very important, Madam Chair. A vote that I took earlier this year was conditioned on tackling this issue. That was when there was a request to reopen the timeline. The reason that I did not reopen it is that I wanted to make sure that we could set a level playing field going forward for everyone, category 1, 2, and 3. And what I'm hearing from Kevin today is that maybe the easiest way to set that level playing field is to let everyone start to curate this data now. So, I don't know. Again, I was kind of confused by the back and forth between you and Councilor Grossman on how we're going to settle that issue, if it's going to be in a separate meeting, if we're going to have an open discussion. But that is something that is important to me, is to make sure that we do address that equity issue that is real and does exist.
Thank you.
And Commissioner Maynard, I got another inquiry from another prospective sports wagering licensee on the same thing. So they are wondering what the parameters of the commission will be.
Thank you. So good. It's something for us to address, and I like the idea that we can consider it in our determination discussions. Okay. Other questions for in section B? Can you remind me if the issues are around the overview of wagering activity is concerning to for the purposes of redactions? North, is that something that you're put forward?
I think with regards to the specifics of how we made determinations around wagering volume or activity, those things would be the nature of how we came about those, and the actual numbers themselves we would consider to be trade secrets. If we want to talk generically about those and the basis for them, I would just say that it's based on our experience of other jurisdictions with similar population sizes and kind of what we've seen happen. But again, all of those estimates are really at this point just estimates. They're the best. They're the best we have. And I think many of us have seen through launches in other jurisdictions that sometimes those estimates are spot on, sometimes they're high, sometimes they're low, but they are our best estimates.
And in terms of offerings, this is an operational question for us. And you happen to be at the beginning, so I'll ask these operational questions and see if we've learned from other jurisdictions. And this is also for our experts, RSM and GLI. We know that you're going to comply with the offerings under 23N and restrictions. I think we understand that, and that's clear in your application. But with respect to the offerings, generally, when a state is launching sports wagering, retail, and otherwise, have you found that given the extensive number of states now that provide this, that they launch with an extensive offering like the one that you're suggesting, or is it a practice to perhaps have a less compress that list of offerings as we roll out sports wagering?
The traditional approach has been on a larger catalog of events that are approved by the commission. So again, the keywords being there, approved by the commission. So obviously we have worked with some of the other operators to suggest to the IEB a catalog that we think is a reasonable catalog to launch with, based on knowledge that we have around certain markets and what we think players will want to be betting on. But again, so there's unanimity, I believe, amongst the operators about what that should look like, but full recognition that ultimately that's the commission's decision.
Teresa, do you want to weigh in on that at all in terms of, I don't know if that's outside of what you've been looking at.
We reviewed the listing as proposed, and then we certainly didn't cross-reference it from a regulatory perspective, just assuming that it was in alignment with the Gaming Commission's guidance on acceptable offerings. I will say that, sportsbook is reliant, the success of a sportsbook is reliant upon volume of wagers, right? So if you only offer a few options, that creates maybe a limited amount of interest for the public. Well, why should I go out of my way to wager on this? Or I'm going to wager on a game that, yeah, I'll just go, wager on that with my buddies while I watch the game, kind of off the books kind of mechanism. I think the value to the public for sports wagering is offering fair, regulated games that provide a variety of interesting options to wager on and seek out that entertainment and excitement from games. So we'll traditionally see a little bit more comprehensive offering listing. There's traditional bets, and then there's in-game bets and parlay bets, and there's some other mixtures of offerings that we will see some variation between jurisdiction. Note that the more offerings you provide will traditionally increase the win rate. If you have an operator or a platform that's monitoring the lines well, people will make wagers that are to the benefit of the Commonwealth and to the operator, versus just straight head-to-head games where the lines are just they have to monitor those lines really closely, and so the hold percentages are typically a lot less.
Very helpful.
It depends on the experience. Yeah, the experience you want to provide the public would be what the Gaming Commission would need to consider.
Very helpful. I think I'm all set on that question. Anything else on section B, commissioners? Okay, then we'll move on to section, at this point, let's just take a consensus then. If you don't have any further questions for anyone on any of section B, do we find that that the applicant has not met, has met, or has exceeded expectations with respect to fulfilling the application?
I would share with you, Madam Chair, that I think they have met what they needed to do for section B, and I'm comfortable with what they put in their application. And I was just going to add with your last comment regarding what would be available for betting and things of that sort. As I went through that list, and I'm very comfortable with what they have put forth for the sports that would be bet on until we have that discussion, of course. But they were basically what we would look at for betting and what sports we would probably look to.
Can I make one quick note on that? As the general industry, what might seem extensive to a new jurisdiction may not be to a jurisdiction that has been doing it for 30 plus years, like say Nevada. So while this list may seem big at first sight, I can assure you that the amount, and Nevada has a commission approval process similar throughout the entire industry. So the amount of types of bets, prices, offerings, and events that have come across a more mature jurisdiction that will make that list look actually probably small.
And what I'm hearing, Joe and Kevin, is that there's not particular need or risk for newer jurisdictions to start with a more compressed list. You haven't seen that, and that was helpful to hear.
Yes.
Kevin saying, okay.
That is contrary to what we, or some of us had heard.
Well, and
So-
that's not on for
Yeah.
discussion today.
Right.
Yeah.
Yeah, it's, I mean, in the end, it's the commission's approval as,
Understood.
Right, I think it's.
But I feel comfortable with B.
We feel comfortable with B. Commissioner O'Brien?
Saying narrowly on the question of my comfort level, did they satisfy the requirements for me for B? Yes, they did.
I also agree, Madam Chair, that they did meet those requirements for section B.
Thank you. And Commissioner Maynard, you're all set?
Same for the record.
Okay, and I am too, so we'll move on to C. I am watching the time, commissioners. Let's try to get through another section before we pause. And navigating my system here. There we go. So section C has a number of component subsections, and they all apply, I believe, to except for P4 to category 1 applicant. This is we can go through each section, or if I can just hear particular questions, that might be helpful. Do I have any particular questions?
I do, Madam Chair, and I'm sure everybody has this question, which is when you're talking about, North, you went through sort of your anticipated increase in sort of the FTEs for putting in the sports book and the bar area. And RSM raised this as well, but I had this question also, which is, can you compare that to sort of what your food and beverage FTE count was pre-COVID, what the expectations were? Is this going to be a net add, or those numbers 10 to 15 and 37 to 45 net adds over pre-COVID, or is that adding to what you're at right now?
Thank you for the question, Commissioner O'Brien. Those numbers are based on where we are right now. I mean, obviously, we didn't have sports wagering before. So for the sports book, those are a net add. For the sports bar, those would be roughly equivalent. They might be off by 1 or 2, but they're roughly equivalent.
Okay. So the net gain, if you go back pre-COVID, is like the 10 to 15 sports wagering specific.
Correct.
Okay.
And that is consistent with what we've seen in other jurisdictions. And as I said in the presentation, there are some instances in which, it's going to be a really busy season. For example, NFL season tends to be, college football tends to be a really busy season. And so we'll probably use more team members than that during that time period. And then as things ramp down in the summer, you're likely to see that it maybe goes back to more to that core group. But we would expect that those volumes the number of team members involved will fluctuate. And especially, there may be a period of time in which retail is the option prior to online. I would expect in that period that there will probably be an initial bump. So we've tried to provide our best estimates of what we think those numbers will be, understanding that there will be variations that happen.
Okay, thank you.
You're welcome.
Other questions for section C? Commissioner Skinner, are you hanging in?
I am.
Thank you.
North, with respect to your recruitment efforts, what do you intend to do differently? As I understand it, the Flutie's bar has been closed since COVID, as a result of COVID, and has remained closed since. I think in your presentation earlier, you specifically said that you believe employment of your female population will improve as a result of the opening of the sports book there. Why do you think that is? And again, very specifically, what do you intend to do differently to recruit for that space?
So the main thing that I would say is that the primary reason of why we believe that it would increase the percentage of women is that outlet traditionally had a higher percentage of women involved in it. So we believe that is likely to happen in that outlet. With regards to our recruiting efforts, what I would say is that I think that if you look at the most recently reported jobs figures, you'll see there's a large increase. Some of the most net jobs added within the country over the past few months have been in the hospitality and leisure sectors. So we feel a little bit more confident that that is going to become a little bit easier for us. I will say that there are a number of things that we have done internally to begin, to make sure that our processes are really working well for team members or potential team members, and making sure that we are getting folks through our process quickly enough. And so I think in this area, I would say our belief is really built more upon just the generally improving business conditions in the labor markets that are evident more broadly, and that our recruitment efforts will continue.
Thank you.
And one of the things we have added, just one of the things that we have added recently is we did make all of our team members benefit eligible on their first day of employment. So rather than having to go through their normal waiting period, we've also provided some hiring bonuses, some other things like that, to continue to be an attractive employer for potential employees.
Madam Chair?
Yes, Commissioner Hill?
No, if I read the application correct, and I think during your presentation, you also said you're going to continue working with your community colleges, you're going to continue working with your Chamber of Commerce, that what you have been doing, but I want to hear from you right now. You're going to continue doing that and getting these numbers up a little bit.
Yeah, absolutely. We certainly will. And we've had some relationships with some local colleges and universities that have proved fruitful for us in bringing in interns. We've seen a very healthy mix, male, female, diverse candidates with that group. And so we'll obviously continue in that direction.
Commissioner Maynard?
Thank you, Madam Chair. So you did bring this up earlier, North, about, as Commissioner Skinner said, increasing female workforce. I know that percentages are hard to get, as in my prior career, I also had to work with the same issue. Is PPC committed to making sure that these jobs are management level jobs? I know that you have management, assistant management level jobs and full-time jobs, or is this going to be heavily weighted on wait staff and entry-level jobs?
So there'll be a mix, Commissioner Maynard, of those. Obviously, the largest number will be at the entry level, because that's just where we need the majority of people to be able to serve guests. On the management side and the supervisory side, we'll continue our commitment to make sure that we are bringing in diverse candidates into the pool, and that we are also promoting people from within who've shown the aptitude to be able to take over management positions. The Emerging Leader Program being a great example of that.
Thank you.
Mm-hmm. And just to add, I'm sorry, again, we report to you on a quarterly basis with regards to our supervisor and above diversity figures, male, female, diverse candidates, veterans, et cetera. And like I said, one of the things that is a joy about working at this property is that we have the benefit on my executive team of being able to say, not only are we at those numbers that we are for the entire property, we're beating them. So whereas our goal is 15% for diverse population, overall, our executive team is 20, and whereas our goal is 50% women on the exec team, we're at 60.
Thank you. Other questions focused on labor and workforce development? Do we want to move on then to other questions in section C? Are there other questions?
Madam Chair, it's not a question for the applicant, but more of a request, I guess, to you and our chief of the gaming agents division. I'm wondering if we could hear from Bruce Band, kind of letting us know what the involvement of IEB has been in PBC's proposal to expand the gaming area, build out this space for the new sports book, and what we should expect as a commission going forward as we consider this application.
Excellent. Excellent question. Again, I don't want to put Assistant Director Dan on the spot. He hasn't reviewed the application, so this isn't about evaluating the application, but we know he's been busy. So yes, thank you.
I've reviewed the plans and everything. We've been working very closely with PPC on this. So far, everything in their plans look great from our view. They've kind of started construction as far as clearing the area on that. The plans look good. They've been 100% cooperative with everything that we've asked of them. And we have no concerns at this point. Do you have any specific questions?
Perhaps just to add on, perhaps ultimately, as I understood today, there would be a request from PPC for an expansion of the gaming area in order to build this out. Did I mishear that, Director Band?
That would be for the final part with the Fluties edition. Yes, that would be. Initially for the temporary, that wouldn't really be the case.
So that would need to come to us.
Yes.
So just to clarify, Bruce, there's no requirement to get commission approval to expand the gaming area for the temporary space?
That's actually on the casino floor itself.
Okay, okay. So it's not within the existing.
Yeah, it's a final product that expands the area.
Okay, thanks. That was an important clarification.
Yes.
Okay.
I have another
Sorry.
question, and North, if you don't want to answer this, you can get back to me, but are you going to keep the Hail Mary pass footprints?
You know, it's so funny. It took me probably 3 months before I noticed that football, which is bad. But noticed the footballs hanging from the ceiling and heard the story. But it's an interesting part of the facility. I don't know if the footprints will remain, but we'll definitely get back to you with an answer.
All right. Thanks.
Fond memories.
I remember the game.
Yeah.
Oh, yes, and we'll forgive you, North, for that 3-month lapse. I'm surprised that wasn't the first thing that Burke and Bruce pointed out to you when they met you.
They went easy. How long an outsider took to notice.
Yeah.
But he's no longer outsider and on Massachusetts. Okay, I have a question that I'm not sure if it's again a protected question, but I did hear from RSM that they're comfortable with the projected revenue in terms of their extrapolation, but in the documents are also some tax implications that were made. Are we comfortable? We are at some point going to be addressing promo play. I think we have that marked up for the December 12th meeting in the afternoon. North, if this is protected, we will take the steps necessary, but can you advise as to whether your calculations have assumed, even though I know you know it's not a determination, has it assumed a deduction for promo play?
I will be happy to cover that in exec session. I know that that's an open question with the commission at this point.
Commissioners, do you want to wait until the 12th for that, or is that, I'm sure that you saw that what I saw, and I wasn't sure if it was all protected or not in terms of the tax calculation. Do you want, if it's important for us to understand those documents better, then we can meet in executive session after lunch on perhaps there are other issues that, I don't know, Councilor Grossman, if we decide that there might be a few items, if that's permissible to go into executive sessions consecutively if we want further clarification.
As long as we're precise as to what we're going into executive session for, I think you could do multiple subjects at the same time.
Madam Chair,
Yes.
May I suggest that we might want to wait till the 12th? Because I think once we have our discussion, once we make a decision, then I think all of the licensees before us may have to readjust their
Okay.
numbers. That would be my suggestion.
I'm fine with that, that we could wait for the 12th, and then I wasn't sure where North would fall on this issue, so thank you. That's fine with me, and I'm fine with the documents that I've reviewed, with the understanding that I think I understand the calculations. Can I ask one more question about the temporary space? I don't think RSM noted anything about the temporary space. Teresa, you're off right now, but if one of your colleagues is available, did construction of the temporary space raise any concerns for you? That would be where they would launch with approval.
Yeah, no, just to revisit a bit about what we previewed in our opening remarks. We had no concerns over the construction. The big issues right now in the gaming and hospitality space as it relates to construction are supply chain issues, and those are primarily based around the construction, the building, the actual building materials. Based upon our limited review and the limited information provided in the application, it does not appear that there's any major structural issues or highly specialized equipment that would impact the ultimate opening of the facility from a construction perspective. There may be delays as it relates to custom furniture and fixture type matters, but based upon our experience with other hospitality-driven organizations, you can often find temporary replacements in order to accommodate the opening in a timely manner. And then once those specialized fixtures or furniture comes in, you can replace those. So I think it's very likely that the operator will be able to open the facility with the proposed timelines and obviously meeting any safety obligations that they may have.
And that's a good segue for me, because this is the bottom line question. Assistant Director Ban, you were part of advising the commission in an earlier meeting where Commissioner O'Brien raised quite rightly the concern around access to kiosks. It was concentrated on the racing area, but we also want to make sure that only of age patrons make their way to the kiosks. Do you anticipate North having, I think Bruce imagined some kind of roping off where there would be security to ID anyone who has access to the kiosk? Does that temporary space imagine that? Or are you imagining something different?
Thank you, Madam Chair. The temporary space is within existing gaming space near the Revolution Lounge. So as with the permanent location, they would have to pass through the security podium in order to access that space, which means all folks who get back there would be presumed to be 21 years of age or higher.
So no need for any kind of, and everyone's comfortable. The surveillance will be, of course, over the kiosks. And then I did hear you say with respect to the permanent would be on an expanded gaming floor. So that would, Bruce, does that suit what you were envisioning? That
Yeah.
because they're on the gaming floor, we're all set.
Yes, yes.
Okay. Commissioner Maynard?
So I have a question related to that and to the construction in general. I am not an expert in temporary cages or fences or moving about money. Bruce, is probably a question for you. Is this pretty standard if you erect a temporary cage? And for the record, Bruce showed me how to get through a hole in a cage once. So maybe that's the reason this conversation's going. Are you comfortable with the temporary structure as is and as described?
Yes. North and I have discussed that in detail, and he's agreed to make whatever modifications we needed to that cage for it to be safe and secure.
Thank you.
Okay, other questions in section C? This of course includes community engagement. It includes, as Commissioner Maynard referenced, security issues, which we do know that IEB will work very, very closely with the licensees on.
Madam
And-
Chair?
Yes.
So I'm just trying to understand North, and I'm looking at, I think C5. I think we can talk about that one, if I'm not mistaken.
Yeah.
So right now, you guys do a phenomenal job reaching out to the community. You work with community groups. You've shown us that with your quarterly updates. So what I'm trying to envision or understand, we're bringing in sports betting, which brings in more revenue. But how does that enhance community involvement? Which is something that I care deeply about. Do you understand what I'm trying to get at?
So, I mean, we certainly were going to continue to be a good local partner, right? I mean, we are engaged across a number of different entities. You know, we mentioned two of them today being New Hope and Boston Pearl, but we're also intimately involved with the town of Plainville, with the town of North Attleboro, with the Attleboro Norton YMCA, with the United Regional Chamber of Commerce, the Tri-Town Chamber of Commerce, the New Colony Habitat for Humanity. We'll be talking about this on our next update, but we are a large sponsor of their most recent habitat build. So, I mean, I think a lot of the types of things that you've seen from us in terms of being a good partner within the community will continue. And, you know, generally look, as we do well, our surrounding communities do well. And, you know, I think that we have a demonstrated commitment in that area, and I don't foresee that changing.
And I think you just answered my question in your last second or two. So thank you very much. Thank you, Madam Chair.
Thank you. I want to point out that Section C does address Massachusetts Lottery Commission. And I want to point out that I know that PPC does report quarterly to us on its partnership with the lottery under 23K. There's an affirmative statutory provision that our gaming licensees are to work to ensure that the casinos and the lottery work hand in hand and not in somehow competitive fashion. And I want to point out that PPC, you've had an excellent record on that front, and the reporting, and I do think you answered that in a way that I feel was sincere, that you will work for the benefit of the lottery going forward in a way that that will support what was clearly established in 23K and what we have now made by policy, at least a paramount objective for us. So thank you on that. I liked your answer.
Thank you.
Madam Chair, I have a question based on that, if you don't mind.
Oh, sure, thank you.
North, does the MOU that was included, will that cover sports wagering also? Is it sufficient to do that, or will that have to be reopened?
Commissioner Maynard, I believe that one will be covered by the MOU that we have with the lottery. You know, we're bringing in a new amenity, but our relationship with the lottery remains. And so I believe that it's covered.
Okay, thank you.
Commissioners, other questions for Section C?
I'll go, if you don't mind.
Yes, Commissioner.
North, just curious, the number of ticket windows is dropping from 5 in the temporary space to 4 in the permanent space. Why is that?
I think probably, so our final plans have not been determined for the final space. I would say that's largely based on our experience in other jurisdictions of what happens when online betting comes into play. That, you know, initially there is a kind of a push or a rush, as it were, that may happen. And then as online wagering kicks in, that volume at the retail level may diminish. So, again, I think this is one where a lot of times we make predictions and that there are very best guesses, and sometimes those are high, sometimes they're low, and sometimes they're right on. But based on what we've seen in other jurisdictions, we think that's right. I'll just say I'm going to put on my hardcore operator hat here and say that, nothing frustrates patron more than having a line and seeing 3 empty spaces in there. Occasionally lines happen in our business just because 15 people decide to come in all at once in an unpredicted time of day. And so we always want to try and match our available volume to the anticipated demand. But the net reduction of 1 is really just that anticipation, Commissioner Skinner, that we think that after retail goes live, after the online goes live, there'll probably be a diminishment in demand at the retail level.
And that makes a lot of sense. But speaking of traffic and volume, you indicated in the application that PPC will engage the local police department for periods of extraordinary volume. Are you able to anticipate in advance what those periods might be when it comes to sports wagering?
So that particular engagement of the local police force, we do that now. For example, we do have Plainville detail that's on site during Kentucky Derby. Other high volume business days, we do bring additional detail if we think that our own security staff will be insufficient. Based on our experience in other jurisdictions, we do have thoughts about days and times that we think that there will be increased volume and increased interest from a player perspective. Some of those will be things that are easy to anticipate and know going forward. A period during certain tournaments for March Madness, for example, or bowl games may be a time of intense wagering activity. Some of them will be ones that a game will pop up with particular significance that was not predicted. A particular team gets knocked out of a tournament and therefore a local team passes through to a tournament or something like that. That can be something where we have less of a 1 month lead time on, but more of a, hey, we got a couple days to be able to figure that out. And in those instances, we'll continue to work with the local fire and police departments on making sure that we're ready to serve.
Mm-hmm. Thank you.
You're welcome.
Madam Chair, I did have another question, but I'll yield to my fellow commissioners if there is another question from either of them.
My only outstanding question, I will wait until we get to the technical component, but it does build on your earlier question about PSI and the integration of Canby into their role of monitoring and setting the line and how it's integrated into staff. So we had similar questions. I'll hold on that. It was prompted by the job descriptions that are provided for your manager position. So if you allow me to revisit that, our tech, Commissioner Skinner, your next question.
Yeah, this
Madam Chair, I'm so very sorry. May I please, Nikisha, I'm sorry, Commissioner Skinner. I just wanted to add with regards to who makes the determination ultimately of whether a wager is accepted or not falls within PPC's ability. That's ultimately our decision to say we will either accept this wager or not. Whether the betting market is available, that decision exists with staff at property. And I apologize for interrupting the Commissioner Skinner.
That's a really good clarification because I thought I saw Canby was setting the line and maybe I misread it. But your job description, I don't think includes that. So I don't know if it's above the manager and it's going to be in your other executive team that does that. But so maybe it is helpful to just clarify that. Commissioner Skinner, thank you for your patience. So is that a group decision, or is that going to be that new position that you're going to be recruiting for?
So, ultimately that'll fall within the management of the staff that manages that area, right? A market could be open from the perspective of our risk manager being Canby, and an individual at the property could make a determination that they do not want to accept this wager from this patron. It could be that they meet a certain criteria that's set out in terms of they're not allowed to place that wager, either by virtue of their self-exclusion or a provision in the law that says, a league has said that they do not want them to be able to wager on an individual event. Those determinations, it could be based on the fact that somebody believes that there is a Title 31 concern with regards to that patron, that they may want to exercise discretion to not accept that wager. Ultimately, again, Canby is there to facilitate the market for us. And I would say, kind of leading into the comments made by GLI, generally markets that are larger are more efficient. From a perspective of a player, having access to a much larger market or risk manager like PSI through Canby is one that is ultimately in the best interest of the player. If lines are set upon a very small betting pool within a very localized market, that pricing that may be available to the guest may vary and be very volatile, and also may not be the best pricing that's available. So that's kind of part of the reason that we see that ultimately as a good thing. But again, just to the extent that there's comfort that the commission has with PPC and with the licensees at the property, those decisions ultimately lie here. If somebody accepts a wager that they shouldn't, it's going to fall to the staff here and not to a vendor.
And so we'll learn more about Canby's role in the monitoring in the next section, but it's really helpful to know about that piece on the wagers. Thank you.
Right.
Now, Commissioner Skinner, thank you for your patience.
Sure, no problem. This next question could easily fall under a couple of sections of the application. So if it makes sense to ask it again later, I'm happy to do that. It pertains to responsible gaming and how that works at kiosks, because I understood from an earlier discussion from folks at GLI that kiosk wagering is anonymous. Did I hear that correctly?
You can kind of view a kiosk as a system that works very closely like the point of sale without a person. It just has a digital interface. You put money in, get kicked a ticket out. Whereas you're not going up to a person and say, give me $100 on the Celtics tonight. You're basically putting $100 in and pressing a button. Give me $100 on the Celtics tonight, and it kicks a ticket out. So it's the exact same.
Sorry, go ahead, Joe. I thought
no, it just works exactly the same as a point of sale over the counter type system. It's just digital.
So as a body, I know we have quite a bit of work to do on the responsible gaming side as it pertains to sports wagering. But what PPC has indicated in its application is that a lot of the measures that are in place on the gaming side will also be applicable on the sports wagering side. And if we could talk a little bit about how that works with respect to kiosks.
Commissioner Skinner, this is one where there's some federal legislation here that I want to make sure that I don't violate. So I would love to cover this one and give you a very fulsome answer in executive session. I definitely have an answer to your question and can give you some comfort on this point.
Thank you, North.
You're welcome.
So we've identified one area where it would require an executive session. I'm wondering, you point out, Commissioner Skinner, that this is an area as a body that we need to be exploring. I believe Executive Director Wells, that Director Vanderlinden is not necessarily available right now.
He is here. He is here.
Here now. So
Yes.
I don't know if he could answer your question more generally in terms of how RG and kiosks relate, and whether we would explore maybe perhaps some more sensitive information as we dive deeper into that. But I really, because I'm not sure what exactly you're thinking about, I want to make sure you're satisfied, Commissioner Skinner. Okay, we've got Director Vanderlinden now.
Good afternoon, Chairwoman and Commissioners.
Commissioner Skinner, do you just, I'm not sure if I invited Mark in. Is it helpful to at least let him know the question that you asked? It's an excellent one.
Sure, I'll take whatever we've got right now until we can get to executive session. Mark, I'm just wondering, given that wagering at kiosks is an anonymous sort of process, as Joe just described, how do we attach the responsible gaming principles and measures that we have in place on the gaming side to those kiosks? So for example, if someone is on the self-exclusion list, what PBC is saying is that, and I cannot remember the exact terminology, and it's possible I could be confusing this with another application, but when you're excluded from one, you're excluded from them all. So if that is the plan, how does that work at a kiosk where the operator could potentially not know who is placed at wager?
So, I think that first, the Gaming Commission is moving forward with a proposed regulation that would separate sports wagering voluntary self-exclusion from casino self-exclusion. And it's up to the licensee then to determine whether they want to blanket exclude an individual. If they're on one list, they would be essentially excluded from casino and sports wagering. That's my understanding of it, though. That may not be the case, depending on how the commissioner weighs in on this. An individual on the voluntary self-exclusion list currently can walk into a casino. There is ID check for some patrons walking through, but there isn't necessarily a positive ID check, or they don't run it across the voluntary self-exclusion list every time somebody walks into the casino. So I think that there would be a corollary to that. In terms of placing a bet from a kiosk, I think I look forward to a further discussion, but when I think that in general from kiosks, there needs to be information related to game sense, related to responsible gaming that would be on the kiosk. So general information, players that are gambling with a player card, my play card, should have access to a full range of limit setting options that and the commission will be discussing those what that entails in at an upcoming meeting through regulation.
Thank you, Mark. And I gather that you would want to make sure that, of course, some of the tools that are available on the gaming floor would be available at the retail sports wagering facility, both the window and the kiosk, and then generally. But if you've raised a point of inquiry, so if we could just pin that possibility of going into executive session, Commissioner Skinner, is that okay?
That is okay.
Okay, thank you. Other questions for section C, commissioners? It is 1:40, and our next section is section D, where we start to look at the responses from diversity, equity, and inclusion. We then go into, for the next will be E is responsible gaming, which includes advertising plans, technology, and then G is suitability. I know we have Counselor Hall available. I want to make sure that she is still available. Then finally we go to the financial stability, which we've heard from on RSM. So we have a good deal ahead of us. Commissioners, we can continue to go in alphabetical order. I also will entertain whether or not you would like to shift to out of order as long as we get through each. But before we move from C and then take perhaps a lunch break, I do just want to go through the exercise of finding whether we have a consensus on this section. So C, I see Commissioner Hill is saying it meets at the very least. Commissioner O'Brien, yes?
I agree.
Excellent. Commissioner Skinner?
I also agree.
Commissioner Maynard?
Agree.
Okay, thank you for your submission on this respect to section C, North, and your responses, and to all who helped guide that discussion. I think we should break now. It's 1:41 to 2:10 for a half an hour. Does that work for you, commissioners? It is going to be a long day, I think, but a very fruitful exercise. We'll come back a little bit renewed to 10. And should we start with diversity? Commissioners, there's something to think about. I'll be flexible when we start off if you have a different order in mind. Okay. Thank you so much. Thanks, Dave. You know, some are here in the office, may have had to go get lunch. Let's see. Great. So again, commissioners, we are reconvening our Massachusetts Gaming Commission meeting number 406 today. And because we're holding it virtually, I'm going to do a roll call. Thank you. Commissioner O'Brien. Good afternoon.
I am here. Good afternoon.
Thank you. Commissioner Hill.
I'm here.
Commissioner Skinner.
Good afternoon, I'm here.
And Commissioner Maynard.
I am here.
Great, thank you so much. We'll move on. We are on agenda item number 5, and we just completed section C of the application of PPC. If we like, we can move right to diversity, equity, and inclusion in section D, unless you feel like we should go out of order. All set? Okay. Then with respect to the section D, do you have questions for North or questions for our team, GLI or RSM? Commissioner O'Brien.
If I could, so I want to start this off by saying that, you know, since I've been here, I've always been impressed with PPC's ability to work on their numbers for the DEI numbers, and in particular laud you for the program that you do to sort of advance women within the organization. I know you've lost some people to other Penn properties because of how well you guys have done, and I want to start off with that. We touched a little bit more, I think Commissioner Hill asked you a little bit about sort of the women and what kind of positions they're going to have when you bring back the food and beverage. I did want to touch on the supplier diversity. I know that when I first got to the commission, the local spend and some of that was a little higher. I'm just wondering if you could speak to the supplier diversity in your application.
So on the supplier diversity, I think that, again, we would consider any spend related to this. Some of it will be things that are not part of qualified spend because they come from a sole source. Some of them would be things clearly that do not. So for example, if I am using a certain company to provide my kiosks, that's a sole source that I'm not able to bid out. So it wouldn't fall within the qualified spend piece. But there's certainly other aspects that we use with regards to that. And then, you know, I think within what you should expect from this, that all of this gets lumped in that, you know, our overall spend, Commissioner O'Brien. I think to the extent I can give you any comfort, I can tell you that I meet monthly with our finance team or with our procurement team to make sure that we are on top of our diverse spend and that we don't get behind it. The worst thing to me that could happen is we come to you to present for a quarter and, you know, I get to the end of the quarter and figure out that we missed a goal by 1% or 2%. You know, I want to know early so that we can react differently. And I will tell you that really this is one of those things that's part of those daily operations that, you know, part of the reason I get to be able to report the good numbers here is that we've got a team here on property who works very diligently to develop that diverse supplier vendor base, and that we continue on that route. With regards to the local spend, some of it, this is kind of a function of what is considered a surrounding community within our surrounding community agreements. There's obviously a lot of towns that surround us here, but there's only a certain number of ones that we have surrounding community agreements with. And so some of those things fall into a Massachusetts spend that aren't specifically designated as local, but they're still within the Commonwealth. And so again, you know, That being said, it's still a goal that we have. It's one that we work diligently to achieve. I think we've got a decent history here, and I wouldn't expect anything different from us going forward.
Okay. Thanks.
You're welcome.
Other questions for General Manager Groundsel on diversity?
Not a question, Madam Chair, a comment. Within the team, I do note that there was a 13% increase in diversity spend from 2020 into 2021. So just kudos there, and hopefully that will continue to increase, over time with the introduction of sports wagering to the Commonwealth.
Thank you. Other comments or questions? Commissioner Maynard.
Just a comment that, I love the LEAP program, the New Hope program, Pearl Foundation, as you mentioned earlier, and really the work that you're doing to put folks into college, and including the children of your staff members. And I just really wanted to highlight that I noticed that in the application. I appreciate it.
Thank you, Commissioner Maynard. We actually had in the inaugural year, one of our team members' children win the large prize. So we have one large prize that's or several large prizes that are $40,000 scholarships. So $10,000 each year for 4 years. And that went to the child of a current team member who is diverse and is pursuing education within the Commonwealth. So we were really glad, and I believe in a STEM field, at least when he initially entered. So we're really excited to be a part of that. I'd also be remiss on this part if I didn't have Erin. She's far too modest to bring this up on her own. So I'm going to have to prompt her to talk a little bit about the work that she's involved with regards to women leading at Penn more broadly within the Penn organization. We here at the property level actually, absolutely have female executives who are involved in that program, but Erin has done a lot of work in that space too. And I thought I might give her just a moment or two to talk a little bit about that program.
Hi, Erin. Erin, I don't know if you're on mute. A little tech issue here. Are you speaking now, Erin?
She is, but she's not.
Sometimes if it's muted on your keyboard, we won't be able to hear you.
Yeah. I'll vamp while she does that and tell you that she does amazing work. She and Wendy Hamilton, our Senior Vice President of Human Resources, we actually both go back quite a ways, probably about almost probably 20 years that we've known each other. And Wendy and Erin have been very passionate about the Women Leading at Penn program. And ultimately the goal there is to make sure that women understand that they are wanted in leadership ranks. We find that there are instances in which women in the company have felt, at least in the past, that there wasn't a path for them to get to an executive level. And so a lot of what we do is letting them know that we do want them to be involved in those executive roles. We do support the talents and the things that they bring to the table and encourage them by making sure that they get good mentors who are people at higher levels in the organization who have navigated that world. And so that's, we can certainly maybe let Erin come back later when she can get some time there. But again, it's something that we take into consideration. We were out in Las Vegas recently for the gaming show, and they actually, a couple of the GMs, self-included, said, "Hey, I really would like to know what's going on with this program and how it is that, are there additional things that I as a leader can do to support the mission of Women Leading at Penn." I don't want to, I need to know from a general manager's perspective, are we meeting the requirements of the program? I want to preserve the space for the women to be able to, have that place where they can come together and discuss without feeling as though they're being monitored. But I still also need to know if we're doing the things that we said that we were going to do and being good stewards in that process. So that's ultimately where we fall on Women Leading at Penn. And like I said, Aaron's been a great part of that, as have many other executives within the company.
Congratulations to Aaron. And I just wanted to add to to Commissioner Maynard's list of notable diversity initiatives, the Penn Small Business Incubator Program. I had that start and I forgot to mention it. So a lot of good work on the diversity side happening.
Thank you.
Just a note, the commission decided to include this as a separate section to have standalone because we value this issue so much. It reflects the values of the Commonwealth, the goals of the Commonwealth as a public, or the commission as a public entity. And you really provided a very thorough and a thoughtful response. And that's because it's backed by great evidence. So congratulations to you on the good work of the parent company and how it shines in Plainville. We're very, very pleased with it. And my only notation would be, it's going to be a reminder to me that the application includes a statement that diversity is the driving force that moves the company forward, and that everyone has a voice at PPC and Penn Entertainment. So thank you for reminding us of those important tenets. Okay, any other questions or comments on this section D? All right, I think I've got kind of a sense of the consensus, but I'm going to go through that. Commissioner O'Brien, nodding your head, all set?
Yep, all set.
Okay, I see Commissioner Hills giving a thumbs up, Commissioner Skinner, Commissioner Maynard, and we're all set. Thank you. Thank you for the thoughtful response. Okay, then we're going to move on to section E. Unless I hear otherwise, we're all set. We'll go right on to responsible gaming. I'll let everyone pause to get themselves organized. Questions? No questions on responsible gaming?
I actually do, Madam Chair, and this is an area where it's a little bit here and it's a little bit into suitability,
right,
akin to the question that Commissioner Skinner asked in terms of looking at mobile and sort of the broader picture for Penn. Barstools is not an applicant for this or your tethereds, but you've been co-branding with them. I think since our Q3 of 21, Penn has been coming in and putting that logo on their PowerPoints on the quarterlies to us. And there's been some press coverage in terms of Barstools and the advertising and the marketing and some of the players involved there. So when I look again at responsible gaming, I'm looking at we're asking you to talk about the commitment to corporate social responsibility in that section. And again, there's a little bit of this and a little bit of suitability in terms of you're going to have a Barstools branded sports bar on the premises according to the proposition that you guys are putting forward. And I'm concerned about some of the historical marketing associated with Barstools, and in particular, when you look at some of the coverage this year, and in particular, the recent coverage in the New York Times about some of the conduct of Barstools. And again, Madam Chair, if this may be partially here and partially in suitability, but I would like to have a discussion about that and some of the things that are brought up in the article in terms of marketing and advertising that maybe is going toward college age students, and then some of the other types of advertising and marketing that you guys have hitched yourselves to, and you'll be taking over 100% over ownership in the near future. So I'd like to have a fulsome conversation about that.
I think that we can have the conversation with respect to looking at just section E, but I don't want to mystify anyone, I believe it is part of the public record that there was a, or at least part of our record, that there was a supplement to IEP report. Is that something that we can address in this forum? Councilor Grossman?
I believe some of that has been marked as
Yes.
sensitive.
Some of it is, but the fact about the New York Times article, I believe that's okay to mention.
Yeah,
it.
certainly. I mean, that's in the public realm. We can talk about that without limitation, of course.
And just to clarify, I wanted to mention that to Councilor Hall, am I not mistaken, did the applicant bring that to our attention, or did that come to our attention?
We did, through disclosures and conversations with Penn, we were aware that the article was coming. And so when we got it, which I know I believe one of the other commissioners was aware of it as well. As soon as we got it, that was forwarded to the commissioners. And then, as you all know, Director Lilios did do the supplement to the executive summary, which I didn't bring up earlier because I know it will, I think, foster some discussion. So I didn't want to derail any of, presentations up until this point. That said, happy to discuss any questions anyone has with respect to that supplemental to the executive summary or the article or anything else.
And the name of the article, just so everybody understands it.
Sure. Give me 1 second here. It's the New York Times article from the, I believe it was November 20th of this year, obviously. And the name was A Risky Wager, Desperate for Growth, Asian Casino Company Embrace Degenerate Gambler. And that link was provided with respect to the article in the supplement to the executive summary.
So that gives a little bit of context. So I think there's some technical suitability questions that will come and evolve, but I also think for the RG discussion, Commissioner O'Brien, there's a little bit more context. Perhaps you'd want to proceed now.
Sure. So in terms of responsible gaming, I know you partnered well with Mark and his team in terms of Play My Way. You were the first ones to launch it at PPC. But when I particularly was going through that article and looking at how, and again, since Q3 of 21, the company has co-branded themselves and put the bar stools as they've come to us, even though we weren't offering, sports wagering in the Commonwealth at that time. And particularly in referencing to the article, they talk about an episode in the end of September of 22, where I believe David Portnoy and other members from Barstools are out near the University of Tennessee. And they talk about the marketing that goes on there. And in your responsible gaming section, you reference the AGA's guidelines about marketing and advertising. And a couple of things that they talk about is not marketing to those under 21. I believe the legal age in Tennessee to gamble's 21. That you're not supposed to deliberately advertise or where it's reasonably expected. That at least 73.6% of the audience will be of legal gaming age, and to not advertise on college campuses. And so that, from a responsible gaming context, wholly apart from personality conversations that we can have, the effort to co-brand with them, and then that will be coming into the Commonwealth as well in terms of this branding and this bar. I'm disturbed by that, and I'd love to have a conversation about how the company is addressing those types of things.
Sure, and Commissioner, it's Chris Soriano, Chief Compliance Officer. Happy to begin the conversation, and great points that you raised, and really appreciate the opportunity to have this conversation about responsible gaming. One of the things that I think is important to keep in mind about the responsible gaming context of sports wagering in college campuses and otherwise, it is somewhat of an evolving area. I think as you see college wagers being taken on college sports, sports shows that take place, that are general content shows that take place near college campuses, and otherwise. So this is something I think that the entire industry is looking at, and it's an important point for the entire industry to be looking at. My point being is, you could ask, this question could be asked, and this dialogue could take place around many others, not just Barstool. So that, I think, is one important place to start. The AGA's responsible marketing code, I think, is incredibly important. And in fact, we're one of the signatories to it, and I sit on the code compliance review board. So certainly something that's near and dear to me, and making sure that we're in compliance as best as we possibly can is something that I think is very important to Penn, as you've seen from our history. A couple of points to think about in this context. There is the concept out there of advertising that is sort of generally made available, signage, billboards, et cetera. And then I think there's the more nuanced concept of specifically targeting to those who are underage. And I think the line as to where that is something that's under a lot of discussion. We, of course, take very seriously that we will not target to those who are underage, that we will not encourage signups, promotions, otherwise, to anyone who is underage. And we have lots of processes in place that if someone who's underage should see an advertisement and decide that they want to sign up for an app, they'll get flagged as underage. They'll get blocked from the system. So I think looking at the more broad perspective of how do we make sure we're controlling this? Well, what are we doing? We have, and certainly Barstool is a company that is very active in the media space. It's certainly on lots of different platforms and lots of different places, something like over 100 different channels of distribution, podcasts, et cetera, 90 some odd personalities. We've undertaken, since we became affiliated with Barstool, since we became a part owner of Barstool, one of the things that we did was impose really strict compliance guardrails on what it is that Barstool does. We regularly train, we regularly coordinate with Barstool. You may have seen that there's responsible gaming content that has been prepared by Barstool. A public service announcement that Barstool regularly tweets out featuring Barstool personalities that discusses the concept of responsible gaming in somewhat of a more relatable to younger folks manner. I mean, I think we're all faced with listening to the concept sometimes of the national sports betting ad that ends with the really small print with a whole bunch of state disclaimers, or with someone speaking super quickly about the different disclaimers. And so one of the things we thought that would be creative here and try to reach a different audience would be to have Barstool personalities prepare a public service announcement that they could then put out, and to talk about responsible gaming in that context, and to weave responsible gaming organically into the content that it is that's out there. Certainly, I think it's important, again, that we follow these guidelines. And so this concept around Barstool's responsible gaming marketing is something that internally we discuss a lot as part of our corporate responsible gaming committee. It's something that we discuss with various responsible gaming stakeholders. Certainly, you mentioned the partnership that we have with Director Van der Linden, and something that we obviously continue to collaborate very closely on. We have experts from the responsible gaming community who we regularly consult with in very candid discussions, where sometimes they tell us that something that they think we're doing is working and something may not be. But that said, I wanted to give this assurance that this is not a concept that we take lightly in any way, shape, or form, and that understanding and evaluating where the industry is going from that perspective, I think, is really important. Erin, I think your audio is fixed, and I don't know if you have anything to add from the operations side. Hopefully we can hear you now.
Wait, Erin, now you are muted. I can see. We're having a little trouble seeing you as well. I think you just might be sitting low on the camera, but I think you do have to unmute now. I just want to pause on what Mr. Soriano said. You were talking about the industry and what the industry is doing. And today we are focusing on the applicant. And I just want to remind you that we could talk about generalities, but we probably should think about this application.
No, certainly, Chair, and I appreciate that. I just wanted to start my comments by saying that this is generally something that as an industry, where I think as operators collaborating to try to understand a little better and make sure that we're implementing best practices.
Right. And I would also, you go right ahead. Now we can hear you, Erin, and good afternoon.
Good afternoon. My apologies. I love that this is memorialized now. My team knows that I'm technologically challenged, and now it's been proven for the entire Commonwealth of Massachusetts to see. So my apologies.
We hold no judgment. No judgment.
So I appreciate the opportunity. And to your point, Madam Chair, I think that's a great point. Obviously, we operate in a larger context of the industry, but here at Penn Entertainment, specifically, I think one of the things that I would point out, and I don't want to cast stones at any of the competition, but what we are not doing is specifically sponsoring any colleges or universities from a marketing perspective with any sports betting agreements. So you have not seen Penn Entertainment enter into any of those types of agreements very purposely. We are very cognizant that, folks will come through those channels and, under 21 folks will be disproportionately recognized there. And so we've made a very clear decision to not enter into those types of agreements. So I do believe that speaks to kind of the broader view that we're looking at in the longer term range that we're looking at here from Penn Entertainment from a responsible gaming standpoint. So with specific questions to the colleges and universities, I do think that's an important distinction for us to clarify from a Penn Entertainment versus some of the other folks who maybe you read about in the article.
Another thing I guess I just wanted to add as well is one of the things about the Barstool personalities is they are very forthright. And, you can see either through their Instagram posts or their Twitter posts, these guys regularly comment about the amounts that they lose, not just the bets that they win. And so I think they set up a realistic expectation as it relates to sports wagering and the seriousness with which they take responsible gaming.
And I would add on to that, North, I agree. And I do believe, oftentimes what a lot of responsible gaming, unfortunately, has been reduced to is a lot of times of folks checking the box, right? And maybe boilerplate information at the end of an advertisement or something. And one of the creative things that I've seen the Barstool team's media arm and their personalities team up with us to do is to create not just talking about some of their realistic wins or losses, but really talking about in very much their own voice why this is important and what they really do and how they do that. And so I have seen that it cuts through, I believe, a lot of the clutter, I would say, in terms of these advertising opportunities as well. Like it's a very innovative approach to responsible gaming. It speaks to younger people in a different type of voice that I think resonates with them and really makes it stand out a little bit differently. That's not entirely the only thing that we do. We clearly do all of the other things as well, but I think that's in addition to kind of that more standard industry, wide approach that we've taken. We've also done some more creative things in partnership with the Barstool team to help get that message across.
So, if I can circle back in particular to sort of the Tennessee example that was in the article, it seemed that there was also sort of a co-marketing for an alcoholic drink when, again, legal age is 21 in Tennessee, you're on the university campus. So I'm reading that and seeing 21 is the legal age to drink alcohol and to game. And yet you have these people out there talking about betting and then, pushing for an alcoholic product. And so, is there anything else factually that you want to let us know in terms of that particular incident, in terms of those two concerns that I raised that I find disturbing, which is when you have the legal age being 21 on those 2 points and you're on a university campus?
I would say, Commissioner, as to the discussion and as to sports wagering, I think one of the important things to keep in mind was this was the Barstool College Football Show, which was broadcast from there. There was no sports book advertisement. This was Barstool Media, so this was not the Barstool Sports Book. This was not the gaming operation, and so it was a more generic college football program rather than a specifically targeted Barstool Sportsbook type promotion.
Yeah, they talk about betting during the program, don't they, once in a while?
I think they do, Commissioner. It's not a sports book specific,
Right.
not
No, I
go
heard you.
bet on this or use us or anything. I think it's
Yeah.
generic content. I mean, when I was on ESPN, they're talking, almost everyone's talking betting these days in that context. So I think it, fell more along the lines of a generic media. Certainly not anyone's intent to target the college campus and underage bettors.
Can I ask this question, and this is a follow-up to Aaron? Are we being genuine here? Because I believe that Penn Entertainment brought the article to the attention of IEB. I don't believe you would have brought it to the attention of the IEB if you thought that they, and I'm using they because you're using the word they, that your spokespeople for Barstools are advocates for responsible gaming. If that were the case, why would you bring that article to the attention of IEB? Because you wouldn't assume that there's some risk attached to that article. So I just want to make sure we're all being very, very, very clear here that the regulators here in Massachusetts are really at a crossroads because the timing of this article is such that's right when we are having these conversations. So now we have an obligation to reconcile what we are hearing, what is very available publicly as to Barstool, and really the significant personality attached to Barstool, and what we're going to do about it as we think about this application. And I'm hearing Commissioner O'Brien, your draft, except for this issue, is excellent on the responsible gaming, and I commend you for it. It's comprehensive. It's beyond A++. You say in it, let me just get my notes right. Forgive me. Oh, here they are, right here. So, the AGA Code of Conduct, and Chris, I know that you're involved with the AGA, adopts measures that, and this is where you say team members, your team, the prized members of PPC are advised through PPC's responsible gaming training of the following topics, and it highlights the AGA's Code of Conduct, and I pulled a few of the words of the measures. These are measures to ensure that marketing reaches the target audience and not underage or vulnerable populations. I'm guessing TikTok, which is a prime Barstool's platform. One might think, and I think in 2021, 25% were underage of the TikTok viewers. I know it's expanding in age, but that the Code of Conduct also reflects generally accepted contemporary standards of good taste. More flexible. And it also contains a responsible gaming message. And I hear you saying that maybe the message is something different. I'll note that in well, first off, I guess I'll continue. You also have a statement that sports book gambling advertising will not, quote, contain claims or representations that gambling activity will guarantee an individual's social, financial, or personal success. The New York Times questions that. And then also that the advertising won't be placed before any audience where most of the audience is ordinarily expected to be below the legal age of 21. And also that advertising does not encourage people to play beyond their needs. Losing a whole lot means you probably waged too much, right? So the idea that there's addressing losing as somehow a responsible gaming measure, it's hard for me to get my head wrapped around. Luckily, we have our own expert, but I just want to make sure that we don't dive into this idea of ironic responsible gaming through the Barstool's personality as being something that that we're really seriously addressing here. Unless there's a whole lot of data that will back it that's for me to understand it. It's unfortunate because I have to say that this shed light for me on this issue. And we're just facing this article at this particular time. I turn to my fellow commissioners. Commissioner Maynard, Commissioner Skinner, Commissioner Hill, Commissioner O'Brien.
I actually would like to see if there's a response to what you just said, Madam Chair.
Thank you. It's a tough one, General Manager Grounds up.
Yeah, so I mean, I would say, so specifically with regards to the incident that Commissioner O'Brien references, that event did not take place on campus. And I understand that there are concerns broadly that people have. That the thing always to bear in mind as well is that, you know, college football games in the South are very large events that include a student body, but probably, I think it's fair to say the vast majority of people there watching are over the age of 21, and the spectators as well. So, I mean, I understand the concern here. I agree with the chair's assertion that, you know, we do take our commitments seriously, and that, you know, when we think there's a potential breach, that we bring it to the IEB right away. And I believe that Chris and the rest of his team, including Samantha, have been very, you know, fulsome in their communication with Director Lilios and making sure that she has the information that she needs and is not left flat-footed in that regards.
And if I may add to that, Chair, to your comment earlier about us bringing things to the attention of the IEB, as a highly regulated company with a robust compliance function, we regularly communicate with our regulators about anything that we think may raise questions on the part of our regulators. So when we knew and saw that an article was coming out, we wanted to proactively get that information to the IEB in the event the IEB had questions regarding it. It's certainly not the first item I've brought to the attention of the IEB on a confidential basis, and so we enjoy that relationship of candor and of placing information in front of the IEB that, again, we may think just be of general interest or may raise questions. But I just wanted to clarify that point. To bring it out there. We could also, certainly perhaps in an executive session, be able to provide audience data regarding Barstool's reach and some metrics that we have regarding it, if that would be helpful.
So, I mean, from my perspective, that would be helpful for me because, again, there's been a branding effort since pretty early on. In January of 20, you buy an interest, and by Q3 21, you're co-branding. And I'm going out on a limb here that the Barstool themed sports betting bar that you want to put in PPC is not the only one of its kind across your property. So there's been a marketing push to affiliate Barstool with gaming. So I appreciate and understand what you're saying, that in the context of the article and the episode that I asked you about, that's not what that was, but there is an overall catch to the following and sports betting. And that's where, when I see that and I see responsible gaming and our desire to do that with you guys. And again, I do want to reiterate that you guys have been great with responsible gaming. North, I appreciate the fact that you heard me in the very beginning say I was not comfortable with kiosks for sports betting being in a pari-mutuel area where 18-year-olds and 20-year-olds were going to be milling around, and you reacted responsibly in reaction to that. But this is still an area, given the marketing push that you're doing with taking that brand and tying it to sports betting, that I do have concerns about that. I would be interested in seeing that data in an executive session.
And to that point, Commissioner O'Brien and others, I think in an executive session, we could also provide additional data on some of our advertising guidelines that we use in-house as well, in partnership with Barstool, in ensuring that where we are targeting advertising, we are doing so responsibly. So I think we would welcome the opportunity to provide you more detail in executive session on that topic as well.
Commissioners, do you have other questions? There is what I'm hearing, that the applicant is reluctant to share advertising data because it's probably protected under the public records. I leave that to General Counsel Grossman to sort that out with the applicant, whether that is more appropriate for an executive session than for the public meeting setting. But I do want to make sure that we flesh out other issues around responsible gaming. You know, as I said, I'm on paper, the responsible gaming section is excellent, and it does reflect everything that we know about PPC. And you led with that, North, at the beginning, and that wasn't lost on me. I'm sure it wasn't lost on my fellow commissioners. So for that, we are so grateful, because you have been a leader in this space, as Commissioner O'Brien pointed out, you know, early on adopting so many of the innovations that come out of the Gaming Commission. But we're not the only regulator who values responsible gaming and knows the import of that. And we also know the operators understand how important it is to regulators across the country and around the world. But as I said earlier, we're at a crossroads right now because of the information that's presented to us. I also want to note, and I don't believe that this is protected, but and I don't have the date, so forgive me, but I also know that in your 10K annual report, SEC filing, you note, is this permissible? Is this public to go on?
Anything that's in publicly disclosed to investors in the 10K would be, yes.
So you know, Penn Entertainment, our investment in and partnership with Barstool Sports may result in potential adverse reactions, negative publicity, or changes to our business, regulatory, or other stakeholder relationships. Our relationships with state gaming regulators, stakeholders, and business partners could be adversely affected as a result of our affiliation with Barstool Sports. In addition, our business partners or stakeholders may react negatively to actual or perceived threats from our affiliation with Barstool Sports and the individuals, influencers, and our media personalities connected with Barstool Sports. So we're not raising anything, none of the concerns we're raising today are private in nature. You recognized it, Penn Entertainment recognized them. And so that's why I say we're at a crossroads right now, because we have an important evaluation going on. So, but I did hear you on the idea that this could be some kind of a responsible gaming approach. I am focused on, and there are other issues, and we know that, but I'm like Commissioner O'Brien, focused on not just the play at universities, but just the messaging around, you know, what I perceive to be glorification of excessive gambling. And I could be convinced, as I said, with data, but that is, it's both, you know, the targeted populations and then just the messaging that is being used and how we reconcile that with our programs. Anything that you want to add, commissioners or General Manager House?
Not at this time.
Okay. So in terms of this being appropriate for an executive session, I think, are there no other questions about responsible gaming in general outside of the Barstool, relationship, the branding? And Commissioner O'Brien is quite right. This is not complete news to us. In fact, we're on the public record expressing earlier issues around branding. It's just, again, now this matter is squarely in front of us. Commissioner O'Brien, is that fair? I think it was within the last year that we publicly have mentioned it, right?
Yeah.
Commissioners?
I don't think there's any need to repeat what was already said, Madam Chair. And since there's been a request to get some information in executive session, I would look forward to those discussions at that time.
I agree. I don't have anything substantive to add, but just an appreciation to Commissioner O'Brien for raising the issue. Barstool Sports is the elephant in the room, and I think we all would appreciate further discussion. Not only on responsible gaming, but on the compliance side, the compliance issues that Commissioner O'Brien alluded to as well.
Commissioner Skinner, are you also thinking about the issue on suitability at all? Because I'm wondering if that we should be thinking about going into executive session for what I do understand is suitability might have some concerns as we analyze that.
I'm sorry, I said compliance, but I did mean suitability.
Okay, that's what I wondered. Thank you. And thanks for the clarification. So,
And I have some issues with that as well, Madam Chair.
right, and I know that that's much, more easy, perhaps, I don't know. Councilor Grossman, can you give us guidance on those two topics? And do we have anything else in terms of the finance, that question that came up? I was fine with my question earlier that I think will resolve on the 12th. Anything else that we are thinking of so far that's come up with respect to a need for an executive session? And then I wonder, does it make sense, let's for a second and go through
Madam Chair?
F and then G is suitability. Sorry.
Madam Chair?
Yes.
I believe if my notes are correct, and please correct me if I'm wrong, but Commissioner Skinner wanted to talk about responsible gaming and kiosks, and we were going to do that in executive session as well.
Yeah, thank you. The kiosk question. Thank you so much. I hope we still have, we have Joe still available. So do we want to proceed with F, section F, and then in G?
That makes sense.
Part suitability anyway. And then if that will give Councilor Grossman the opportunity to perhaps consult with the applicant as necessary. If that's necessary, Councilor Grossman. But let's go right to F, and then we have the benefit of GLI available still on those questions. Questions in section F, commissioners. A quick pivot. I guess I'll open it on a general question. North, I thought it was a very, very helpful, again, piece of your application. I guess I raised the issue around Canby, and as I understand it, Canby really is almost like is the integrity monitor for you, but then there's also another, is there another, I think you referenced it, the national monitoring system too. Could you just explain that so we make sure we understand that, and then how it's integrated into PPC staffing, please?
Right. So with what that part references when it's talking about the integrity piece is monitoring for betting patterns that may indicate somebody acting illegally or trying to exploit a market. And so what ends up happening there, I probably don't want to go to in this too much in a public of exactly how, but to just say that we do monitor for suspicious activity. And we have ways of coordinating with other books to be able to look to see if they also see suspicious betting activity that would make us call into question the integrity of any individual match.
And Canby's real name, just because I think probably many of us have met at least or interacted somehow with folks from Canby, but Sports Information System, they will be a contract, you'll have a contract with them, or is that through PSI?
So PSI would hold the contract. Our contract is with PSI.
Okay, and then, but Canby is separate and apart.
Correct.
Madam Chair.
Yes, Commissioner.
I have a question based upon that one. In my notes, I have written that Canby and PSI would quote, ensure that data breaches will not occur. There've been some issues. I for one, probably shouldn't say this publicly, but I use passwords on multiple different platforms, right? The same one. Not all of them, but a few. We've seen that breach can occur in this industry. What PSI can be, whoever is monitoring that, would they have the regulatory infrastructure in place? Would they have the infrastructure in place to catch this happening, right? So if money gets out, starts being spent quickly, and then let's say, is there someone to pick up the phone on the other end? That's really what I'm asking. Is there someone to pick up the phone if this happens, and they can get this shut off quickly? Because a lot of people have their bank accounts tied to these accounts.
So, Commissioner Maynard, thank you for the question. I think, just to be clear, so this really, when we're talking about Canby in the retail setting, we don't have accounts that players are registering for in the retail setting. So in the retail setting, there should not be a concern. That's not a service that Canby's providing to us at the retail level.
So this is a better question on the Cat 3. I'll table it for the Cat 3.
Yes, sir. I will tell you that they will be much better at answering your question than I will.
Put a pin in that, Commissioner Maynard. It's a great question. Okay, any other questions on the for GLI, even to understand some of the responses? We have our experts here.
Madam Chair, I have a general question. Joe, in your presentation, you walked through the steps that an applicant is required to undertake to begin the technical compliance process with GLI. Short of that, I mean, is there any guidance you could give commissioners in terms of the sufficiency of, the technical component of PPC's application? Just in terms of, making a determination or coming to a consensus that this particular section of the application has met certain requirements. Is there any guidance you could give to us as we review that question?
I think what might help you is to understand that PPC, actually specifically Canby, has been certified in, I wouldn't doubt if it's over 25 jurisdictions, even more if you went worldwide. Canby specifically has been around for 15 years providing sports betting platforms and systems and applications in the compliance world, in the European markets, and was here first in the United States. We work directly with them all the time as they submit for all the other jurisdictions sports betting in the United States. So, and actually, what the process I laid out was as if one of the operator was going to come to us fresh. We would actually start off, given that it's going to be Canby and the relative third-party pieces that they commonly use, running a differential between the mass state regs that will be approved by the commission and GLI 33. Because they've been through the lab so many times, the process is still the same. It's as thorough and as complete on the tech side as you can imagine. But we're so familiar with the way their systems and engineering is outlined. It brings them to an easier path to the lab, so to speak.
Thank you. That's helpful.
Other questions on this section? We didn't take any kind of a consensus on E because we've got work to do, but I would like to be able to find out how we feel about F, if you've had a chance to answer all your questions. Excuse me. Do we have, are we okay with this meeting expectations? I see nodding heads from Commissioner O'Brien, Commissioner Hill, Commissioner Maynard, and Commissioner Skinner. Are you comfortable with section F?
I am, to the extent that I understand it. You know, it would just be helpful to have, you know, take a couple minutes to understand which components are relevant to the retail sports book as opposed to the online operation.
And if I may, to Commissioner Skinner's point, I agree. The reason I was having a little bit of trouble and asked the question I asked is because I don't know how much crossover and bleed over there's going to be from your app to the kiosk to the window, right? Which is why I did ask the question.
Commissioner Maynard, to be clear, it's a valid question because with regards to the way that the kiosk presents the lines, the underlying software that helps with all of that, that is within the purview of Canby's service provision. So they will, some of the risk management pieces and some of the software will touch that. The only piece that will be separate would be the account basis, which I think was the basis of your question. Really was just like, you know, from an accounting standpoint, do they have good security controls? I will say, adding on top of all of that, at the property and at the corporate level, we do have IT security compliance meetings where we regularly review our processes to make sure that there are not opportunities for data breaches. You know, these things can happen, but it is certainly something that we monitor both at a corporate and a property level.
Any further questions on that or follow-up questions? Commissioner Skinner, you, the GLI is available. There's no question that's, but this is the time for you to get comfortable with it. We can always go back, but if there's anything that's troubling you in particular.
No, nothing in particular, just a general, I mean, a general understanding of the technical pieces would be helpful. I mean, you know, we've gone through our GLI standards process, so we've adopted the standards for Massachusetts, but then overlaying those, I guess, with what we see here presented in the application, I guess will come at a later time.
Maybe I could do this follow-up question because it's very fair. Joe, you reviewed section F. Did you review section F of the application, Joe?
Of the application, I can't say I reviewed the technical expertise and reliability portion.
Yeah, so the technology reliability. Yeah, so that's on the wager acceptance.
But as for the whole section, I'm not sure.
Great.
Okay.
Yeah, so I think that's what we're looking at. Was there anything that stood out to you that concerned you with respect to the integrity of the technology or the capacity of the technology?
Nope, nothing. Everything seems fairly standard coming from the technical perspective.
Can I say standard and best class?
Yes. To the highest of.
Well, that's helpful to me. Thank you. Is there any other question with respect to F? Commissioner Skinner, the others have indicated a level of comfort to proceed. We can note that you might want to revisit this as we continue today. Okay. All right.
Excuse me, Madam Chair. I actually can share my screen real quick. It may actually solve a lot of questions that Commissioner Skinner and maybe others have.
Okay.
I have a very high level document that outlines kind of how sports betting systems work. And this may streamline some of the confusion between what piece is digital and what piece is not. and how they are related. So let me try to do this really fast.
And that's particularly important to me, Joe, because, you know, it was said at the beginning of this session that we are considering PPC's Category 1 application for retail operations. And so if
Can you guys see my screen or hear me still?
Yes, we can see the screen.
but just
My
to
computer's
finish,
acting up really quick, so I'd rather go real fast here.
Joe, I don't know if you can hear me. I was in the middle of a sentence. I just want to complete my thought.
Sorry.
Where we're struggling, or I'm struggling with the question of PSI versus PPC. And a lot of what is contained in section F relies on the PSI retail operations, as I read it. I just want to make sure that we are parceling out, I guess, for purposes of this Category 1 application, the pieces that are relevant to the retail sports wagering operation. And that's important because we haven't reviewed the PSI portion of the application. Thank you.
Can you guys see the diagram on my screen?
We can.
Okay. So this is just a really high level overview and maybe clarify some of the confusion. I tried to simplify what a sports betting platform and sports betting systems and how they interact between the Cat3, like the digital mobile applications, and the land-based or retail applications. So you see down on the right, you've got the data and the risk management. This is feeding into, because all the prices and all the events, that data is going to be the same. So it's handled on retail and it's handled in mobile. So that's brought into the main sports betting engine server, and all the bets are placed on it. And typically, and certainly in regards to Massachusetts, these servers are actually physically located within the borders of Massachusetts, as discussed many times, to satisfy the Wire Act. This is where the bet is accepted actually within the geolocation and that is to be further outlined by the commission on where the actual physical locations of the servers will be.
I think the applicant here did indicate that in the application.
And you can see on the left, there's the difference between the left and the top is the lack of account-based wagering, where the account-based wagering is operated by a player account management system or PAM platform. Whereas over the counter and kiosks are non-account based wagers. In other words, $100 on the Celtics, kick out a ticket, move right along. But all of it works off that main component, that main sports betting engine server. So this hopefully can clarify. Today we're discussing that bottom piece, those bottom pieces, and how they can get stood up so that Penn National can take bets at their facility. Does this help?
I think this helps. Commissioner Skinner, I think it shows how your earlier question, and I think we're going to discuss in executive session, how the kiosk or the retail is really quite separate and part of the KYC.
Yeah, so I think the better term is probably non-account based wagering.
Oh.
Because if the patron is to look underage or walk into the facility, they could get their ID checked. It's very, honestly, it works exactly like how somebody would place a bet on a slot machine.
Yeah.
It's the exact same. And if they place a bet over a certain amount, I believe right now in discussion is $10,000 or more, they go into a separate process where their ID is checked and they're verified. So those rules are still pending. So non-account-based wagering is likely a better term than what I said earlier, anonymous. It's technically non-account-based wagering. So, cool.
Very helpful. Commissioner
Okay.
Simmons?
I agree. Thanks, Joe, for providing the clarification. This visual was very helpful.
Okay, I'm gonna stop sharing my screen, and I've given this to Katrina and others, and I'll make sure the commission can have this for their reference.
Okay. Other questions and very good clarifier on section F? Okay, then Commissioner Skinner, again, I understand that we have at least one question that needs to be clarified. Are you getting more comfortable with this section?
I am. Yes. Thank you, Madam Chair.
Thank you. All right, then I think we have a general consensus. Should we move on to section G then? And this is where we will get into suitability as well as, I just want to get the application in front of me because it's quite technical. So we're looking now at, it's the last section, and it's suitability in the individual, the corporate integrity piece. Then it's the individual qualifier integrity piece. But it also includes the financial stability and integrity, which RSM did address, and then compliance, which is a little bit more general. I wonder if we should just focus right now on G3, financial stability and integrity, and see if there are any follow-up questions you have for our folks at RSM, if they are still hanging in there with us. Do we have any further questions? I'm turning to my notes. Commissioners, did anyone lean in? We may have answered them along the way. I want to double check my notes. I'm all set on that piece. No other questions on that particular section of G, my apologies. In terms of questions that relate to section G that would be for the public forum, do I have any questions on that? Commissioner O'Brien, are you saying yes or?
Just to put a finer point on why I reference this area is it's somewhat related to the responsible gaming and the advertising and the marketing, but it is, again, the branding that's been happening, particularly with what's going to be on site and Barstool, to not acknowledge the fact that there is a lot that goes with David Portnoy being the main marketer of Barstool, and that the applicant has hitched itself to that company, to that brand deliberately. The bar in PPC will be named after it, et cetera. That, to me, not delving into what that means in terms of suitability, honesty, integrity of the applicant, I think bears a discussion by this commission. It's why I brought it up the first time, and why I would bring it up again in this context.
Thank you, Commissioner O'Brien. And if I could just add just a clarifier, and you can let me know if I've got it right, but the reason why, just a reminder that suitability with respect to Barstool, that is not the applicant today, and we recognize that.
Right.
Are looking at the suitability of the qualifiers and the entity itself. And I think that's why it's germane to today's session, correct?
Right.
Okay, so are there other thank you for that. Again, Commissioner O'Brien for bringing up and clarifying. Commissioner Skinner, do you have other questions about with respect to G or section G?
I did, but I think I just answered it in my head. It was regarding, I think I'm okay. It was regarding questions G4, E, F, and G that weren't answered with respect to PPC, but we do have the executive summary regarding the suitability for PPC. So I think I'm good.
Okay.
Thank you.
All right. So we need, why don't we take just a 5-minute break? I think we'll need some guidance. I want to give General Counsel Grossman the opportunity to get guidance together. Is 5 minutes enough, Todd, or should we make a 10-minute break? And then I'm imagining that we are anticipating going into an executive session or sessions, and I'm not sure if we need to come in and out or if we can do that in the collective way. And then we'd have to make a determination whether or not we will be coming back to the public meeting. So do you need about 5 minutes or 10 minutes? And North, you might want to take a quick break as well. How much time do you guys need?
10 minutes would be wonderful. Thank you.
Okay, great. All right, then we'll pause for 10 minutes. Thank you very much.
Thank you.
Thank you. Sam or somebody, can someone please confirm if this is working?
You're good, Aaron. We hear you.
We hear you. Oh my goodness. My apologies to everybody. Thank you.
Aaron, no worries. We've been living this world and we navigate it well. Thank you so much. And if you want to add into what was the great question that you want to add in later, we'll take it. We would love to hear about that initiative and anything else you wanted to add. Thank you so much.
Thank you, Madam Chair. I appreciate it.
Thank you. Thank you, Dave.
It wouldn't be New England in December if it wasn't almost pitch black at 3:40.
That must have been a change for you.
It was. But you know what? I do. There is a part of me that enjoys just the natural rhythms of the year. Like, oh, we're getting to the part of the year where the days are shorter. And then come December 21st, the days will begin getting longer and there's hope out there and all those types of things. So I do somewhat enjoy that. Yeah.
I do start listening to, the weather person about what time the sun is going to rise and what time it's going to set. I'm with you. But it is dark right now.
Noah, thank you for trying to make us feel better about the way we do our time zones here in New England.
You know what? I have learned, Commissioner Hill, each place I live to appreciate it for what it is and not trying to make it into something different. So
when my daughter was living out in Idaho and it was 9:30 or 9:45 p.m. and the sun was still shining, I'm like, oh, how nice this is.
Yeah.
Different world.
Yes, sir.
Yeah, we were in Iceland and I felt like it extended our vacation because it was still light out. Yeah, more hours for fun. All right, so we do have business to attend to. Are we streaming yet? Continuing to stream, Dave?
Yep, we are back and ready to go.
Okay, excellent. Thank you. So thank you all. We are convening once again our meeting today of the Massachusetts Gaming Commission, and I'm going to do a roll call because we are again using our virtual platform. Commissioner O'Brien, thank you.
I am here.
Excellent. Commissioner Hill.
A very dark place. I am here.
That's only because we're talking about how dark it is outside. Yes.
That is accurate.
Yes. And Commissioner Skinner.
I'm here.
Excellent. And Commissioner Maynard.
I am here.
All right. Thank you very much. We can get started. And just to remind everyone where we left off is that we recognize there were a few matters of import, and for us to really have a fulsome discussion, we needed to probably think about going into executive session, and that requires the commission to vote. But first, before we get started, I'll have General Counsel Grossman give us some advice.
Well, thank you, Madam Chair. Yes. So as described earlier, there are provisions of the law that allow the commission to move into executive session for the purposes that have been outlined. But I just wanted to add a little bit more color to that, if I may, in advance of your vote. So, of course, we can't go into executive session just to discuss sensitive information in general. It has to be in accordance with Chapter 30A, Section 21, and one of the enumerated purposes. In this case, Section 21A7 talks about going into executive session for purposes of complying with any general law. And in this case, under Chapter 23N, Section 6I, there is a provision that talks about certain pieces of information that may be withheld from public disclosure under the Public Records Law. And it provides that if we are dealing with trade secrets, competitively sensitive or other proprietary information that's provided in the course of an application, the disclosure of which would place the applicant at a competitive disadvantage, it may be withheld. So the two areas that have been identified here would need to fit within the construct of Section 6I. That is to say, the commission would need to conclude that the information is either a trade secret, is competitively sensitive, or is proprietary, and that if we discussed it publicly here, it would place the applicant at a competitive disadvantage. So I think the first thing that is important to do is to identify precisely what the information is that we will be discussing. In fact, the law requires that specificity. And it says that you have to be as specific as possible, essentially, without compromising the purpose for which you were going into executive session in the first place. So I think it would be helpful if we just took a few moments to talk about the two areas that have been identified. And as a general matter, I wrote down that the first one related to certain advertising information relative to Barstool Sports and associated data that will be helpful in understanding the advertising plan. So that's one of the areas, and we should polish that to the extent possible to make sure we're very clear as to what the commission is intending to discuss. And maybe we stop there before moving into the second. Did I have that right?
I think I had asked that I was open to hearing data to understand better the advertising plan and the responsible gaming tactics.
And particularly as it relates to under 21. And so they were going to get into some of their demographic information. So to me, that goes into maybe competitive disadvantage if they're going to be talking about it publicly.
I apologize. I did also want to provide some additional context for Commissioner Skinner regarding a question she had around kiosks. And again, there's some information there that in executive session will become more clear why we're asking that to be protected.
So I think that's the second issue, and we should get to that too, because I just want to be clear what the specific issue is without compromising it, of course. But
it's okay to make it. I really appreciate Commissioner O'Brien wanting to be particular around the underage, but I also thinking responsible gaming generally too.
Right.
Okay. Yeah. And so that's one area. Is that and that comes under.
I suspect that. Well, it seems to me, and maybe North can add some color to that, or Chris or Aaron, but that sounds like it would be competitively sensitive. It's not necessarily a trade secret or proprietary, if I have that right.
Which part?
Well, let's talk about just the advertising issues.
The advertising marketing issue.
Yeah. So the actual demographics of the demographic breakdown that we wanted to be able to provide in executive session is stuff that's not public knowledge. And so that is something that we would consider to be a trade secret.
A trade secret, okay.
That would be trade secret, and then the other might be.
Right.
Right. The broader discussion is probably the competitive.
And with regards to the kiosk issue that Commissioner Skinner referenced, I believe that would fall under the public records law. I believe it's section N that talks about safety of people in buildings. There's some pieces in there that, again, I'm happy to discuss in executive session as it relates to responsible gaming. I'm sorry, I can't be more fulsome in this discussion here.
Okay, and then and then was there another piece?
In terms of the suitability?
Yeah, the suitability, where does that fit in?
So in the Barstool, I'm basing this somewhat on having seen the redacted and the unredacted that competitive sensitivity, I think, is where I would put that.
I think that would work.
And I would just also note, Chair and Commissioners, that there were two other exhibits that were marked as requested as confidential that were attached to the executive summary. And maybe Commissioner O'Brien is referring to that as well. I just wanted to.
Those two, and then there's a partial on something else. Yep.
Okay. So the suitability relative to Barstool Sports is a separate issue from the advertising related one, I believe, even though they both involve Barstool Sports. And then the third issue is the use of the kiosks vis-a-vis responsible gaming. So there are three separate issues, which is okay, as long as we've identified them. And those are the issues we're going to discuss and not anything else.
And I apologize profusely. This is Erin. Hopefully you guys can hear me. If you wouldn't mind, I would like to, just given my technical difficulties there, I wanted to make sure I was clear on some of my RG comments before we kind of moved into some of the exec session. That might help a little bit. So just really briefly, and I know there's probably other stuff that we will address as well. But when I was discussing some of the more creative RG messaging, I don't think I was extremely clear. And I want to be very clear on this topic because it is very important to me. I've been doing this for a long time and have been regulated in many jurisdictions, and that reputation is very important to me. RG is something that we take very seriously. Everything that I was talking about is built on the foundation of everything that we have done on Plainridge Park. We will not change that. We will continue to add to that. We will continue to build on that. So all of the different programming that we do, all of the different advertising that we do, all of the different messaging that we do to support responsible gaming will remain. In fact, we'll continue to learn and innovate and grow like we have over the past 7 years in the Commonwealth, and adding to that and getting better every single day towards responsible gaming. So I want to be very clear with that. What I was trying to say, and inarticulately did, is that we also believe there's additional ways that we can reach more audiences with responsible gaming. And so we always want to be at the cutting edge of responsible gaming. We believe this is one way for us to add to what we're already doing and what we will continue to do. And so, for example, the messaging that I was referring to were a couple of media personalities from Barstool who actually did a pretty creative, responsible gaming message. That message has actually been viewed now over 1 million times by folks who probably, maybe we could guess, wouldn't have listened the same way to that message as they did to other messages. And it maybe made a different kind of impression. It was in no way intended to replace anything that Plainridge Park, Penn Entertainment, anybody else would do. It was simply to support that in a new and different way. And so we're really proud of the fact that we've built this long foundation. I didn't want to disparage that in any way, shape, or form. So my apologies if it came through that way. What I meant to say was we also believe we can continue to add and grow and innovate there. And in fact, I just learned while we were on break, in fact, that we are, PSI was the first US-based sports gaming operator to receive the Responsible Gaming Council's RG check. So we continue to try and work with different groups, make sure that we're bringing that message out. And so hopefully that adds a little bit more clarity, and I'm, be happy to answer any questions on that. But I did want to make sure I was really clear on that because it is really important.
Very helpful, Erin. Thank you. Other comments before we take the steps needed to go into executive session. And Erin, it's nice to hear you. Okay, so it's my understanding, General Counsel Grossman, that I, as chair, must read this language into the record, and then my fellow commissioners and I can decide whether or not to actually go into executive session. And is it written, or are there any changes that I need to make? Because I know it has to be read precisely.
Yes, Madam Chair. I think this situation is a little bit different from the ones we've encountered in the past, in that when we wrote the agenda entry, we didn't know specifically what the information would be that we would be moving into executive session for. So I think we'll need to include the 3 specific reasons within that paragraph. And I can help you with that.
Thank you.
Just have one second. Okay. I just sent you a message via email, Madam Chair.
Thank you. Let's hope I am.
We could actually, oh,
Okay, there we go. I got it. So again, this is pursuant to the public records law, right? Or the open meeting law, I'm sorry. That right now the commission anticipates that it may move to go into, that it may go into executive session under chapter 30A, section 21A, subsection 7, for purposes of compliance with chapter 23N, section 6, little I of the general laws, to specifically discuss advertising issues related to Barstool Sports and a review of associated data, to discuss the use of kiosks related to responsible gaming, and to discuss the suitability of Barstool Sports as these matters relate to trade secrets, are competitively sensitive, and or proprietary information, the discussion of which at an open meeting, public meeting, would place the applicant at a competitive disadvantage. And commissioners, I would need a motion if we do want to move into executive session.
The only clarifying thing I think I would do, Madam Chair, is that the suitability is as to the applicant, but in connection with Barstool.
Okay, so, and to discuss, so the motion would be amended and to discuss the suitability of Barstools.
Well, to discuss Barstool in its connection to the suitability of the applicant.
Yes, to discuss Barstool in connection with the suitability of the applicant as these matters relate to trade secrets, are competitively sensitive, and or proprietary information. Discussion of which an open public meeting would place the applicant at a competitive disadvantage. Do we need to read the whole thing into the record again, Councilor Gressman, or is it good?
I think it's clear, at least to me.
Yep, our record will record that. So do I, so that motion is made with that clarifier. Do I have a second? Second. Thank you. Okay. Any further edits or discussion? All right, Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Grossman. Honey, I just gave you. Commissioner Maynard. Sorry, Councilor Grossman. And Commissioner Maynard, it was an aye. My apologies. And I vote aye. Yes, thank you. 5-0. And my apologies.
And just for the record, I just wanted to make sure. So I'm being attributed with moving, correct?
Yes, you were the moving party. Yes, with your
Okay.
with the clarifier. Yes, you were the moving party. Yeah, because I just offered it. All right. And then my apologies, General Counsel Grossman, I made you a commissioner there for a second. I don't know.
Well, you don't have to apologize for that. That's flattering. We should also, of course, just clarify whether we'll be coming back into public session.
Yeah, so that's the next topic because as I stated at the beginning, we could decide to make our decisions today, or we could decide to continue this matter for future discussion. We could also decide to make a partial decision today. Commissioners, thoughts?
I believe Commissioner Skinner and Maynard had some questions that they thought might be answered more specifically when we get to the tethers in connection with these applications. So I don't know if a partial or a deferred makes sense then in that context.
Agree. I think, in order to have a more comprehensive discussion around PSI and its relationship to PPC, the applicant, I would be in favor of postponing a deliberation relative to the approval or denial of the application.
Are we in agreement on that, commissioners?
We are.
Commissioner?
I would have a question. I'm not sure if it was from Karen or Todd. I would like to see, what that means as far as what we're doing to hold that vote. Would it be holding the vote till after all three of the category ones, or are we saying till after every application all the way through the category threes? I would like to know the implications before I make a decision on that.
Commissioner Maida, I may be able to answer that question. I think that particularly if you are making the determination, say at the beginning of January, we will operate, particularly for the category ones, because there's a shall in the statute, we will just continue to operate so that there is no potential slip in the timeline. So for example, if you complete the promulgation of the regulations regarding the internal controls, which is scheduled for December 15th, we would go ahead and have them submit the internal controls. We would go forward with the process regardless of whether the vote has been completed or not.
Okay, so I see no reason why we wouldn't get more information then before we take the vote.
And this is the 12th and the 13th, right? We would get more information in particular about the tethered threes, is that right?
Yeah, the 12th is the hearing, the public hearing. The 13th and 14th will have evaluations.
13th, 14th.
The 19th, 20th on the tethered. So 13th, 14th, 19th is fine.
Okay.
Need be. And my thought would be that we follow suit and be with plain BC's tethered first, if that's helpful. And there's, we can put this deliberative process in front of another public meeting or another hearing. We can, well, it's harder and harder to find time. The calendar is stretching and accommodating us one way or another. So I'm sort of hearing people are comfortable with perhaps, first off, we can return after this discussion. We could reserve that right to return to public meeting in the event that we have from our executive session, any questions that we want to ask folks. Or we could decide that we're all set and then we won't convene back to the team and experts that are here. That would not be going into the executive session. And then I guess Councilor Grossman for our team will need to know who should be part of that executive session. So commissioners, do you think, how are you feeling?
Do you really want to know that?
No, do we feel that we want to come back? We would ask people to be, would stay within earshot, or we could say that we won't be reconvening, and that would, we would be giving notice to the public.
What would be the purpose of reconvening this public meeting, Madam Chair?
Well, it would be to come back to the public meeting to perhaps, should there be any information that comes out of the executive sessions that would prompt additional questions on the application. Because this is, do you want to reserve that, or do you believe you're all set?
I believe we're all set and don't need to come back after the executive session. That's one commissioner's opinion.
One commissioner.
I think there's a lot to digest from what we've heard today. It's been almost 6 hours worth of information. It's been great information that needs to be digested by all of us.
Commissioner O'Brien, Commissioner Skinner, Commissioner May.
No, I agree, because we can always, if there's something that we want to do publicly before we vote in December, I think we would have time to do that. I don't think it would be so time consuming. You couldn't do it then.
Okay, Commissioner Skinner.
Would we be able to address any outstanding questions on the 12th or excuse me, the 13th, when we convene again for the PSI application? Yes, okay. Then I'm in favor of closing this public meeting out and moving into executive session.
I just want to clarify, this is today's public meeting on the CAT 1. Could we reconvene on CAT 1 on theirs? Yes, but I wouldn't want to merge. I don't want to merge necessarily the category 3 and CAT 1. It's already complicated enough as we struggle today to segregate the two. Does
Yeah,
that still
but
make
when
sense?
we vote, we can always have it on for final discussion,
That's
right, before
right.
the vote.
That's right. I agree with that. Commissioner Skinner, is that clarifying?
Yes, it is, except that, I think, like it or not, the applications are somewhat merged anyway, so.
Right, we just might put them separate for deliberation, that's all.
Sure, yes.
All right, and then Commissioner Maynard, are you all set to?
I've exhausted my questions, but for what I believe is going to come up during the executive session.
All right, then I note then that the public session of the commission meeting will not reconvene at the conclusion of the executive session. So technically what happens here is we leave this virtual platform and then we go into another virtual platform. And North and team, I presume you have the link to that, okay? North, you probably have done this before, so you're familiar with the process. You have
I
it?
am familiar. I have not yet received the link, I don't believe.
Okay.
But I'm happy to forward it to the other folks from Penn who would be participating.
I actually haven't received it yet either, Chair. I did get an invite for Friday, and I wonder if perhaps it was the wrong date.
It's not the same, Heather. Madam Chair,
It's for this.
the people that you
It was for
want,
today.
One at a time, please. Executive Director Wells.
Madam Chair, if the commission would just indicate what staff members or consultants you would like in the meeting, I'll coordinate with Crystal and we'll send the executive session invite to those parties.
So we need to make sure that North and Company get the link.
I'll
And
send
then
it forth. Yep.
Commissioners.
Heather, Todd.
And I would like Kathleen Kramer as well, as we're working closely on these reports together. Thank you.
Okay.
Bruce Band, anyone from the gaming agent team?
Commissioner Skinner, is that relevant, you think, for your kiosk question?
I think so, but I was kind of trying to defer to Bruce. I don't see him on. Oh, I do see him. Right. Bruce, if you're available, I would like you to participate.
What about GLI, RSM, or do you want some representation from there? Maybe GLI because of the tech issue?
Is that within the parameters of what's allowed by law?
So are we gonna have to segment this so they're only in for where they're relevant?
No, yeah, it's okay if they're there, as long as we're only talking about the specific issues that you voted to move into executive
No, but I'm
session.
not so sure that Penn wants GLI in.
Well, that's a good
their
point.
time.
They might not. Yeah, so yeah, we might
I
need
can
to
always
invite.
circle back with questions directly to GLI.
We could circle back to them as need be, Commissioner Skinner, right? So I think that makes good sense. I think we've got the right folks.
And of course, we'll bring our lawyers with us as well, if that's okay.
Okay, thank you. Yeah, I was just going to add Kristen Gagelas from Anderson Krieger. I'm taking minutes, so I believe I'm also supposed to be in the executive session.
Yes.
Okay, thank you. Anyone else? All right. So again, thank you to the entire team who's part of today's presentation. RSM, GLI, thank you for your expertise. And at this point in time, the public meeting, we don't move to adjourn?
No, we'll adjourn in the executive session, right? That closes the whole thing.
Right.
Okay,
Yes, we do need to remember to adjourn the meeting in the executive session.
Wait, at the executive session level?
Yes.
So what I say then is thank you, everyone, and we will now conclude this public meeting. And we appreciate everybody's attention. Thank you so much.
That are getting the invitation. It's a 10 a.m. meeting. Just click on the 10 a.m. meeting. I just forwarded it to you, North, and to the folks at the Gaming Commission. Todd, can you send it over to A&K? I didn't catch that.
Yeah, they have it.
Okay.